You are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to season 2 of Based in Fact, a true crime podcast. I'm Lisa O'Brien, and I'm joined by my co-host, Kyle Evans. This is episode 8, Oklahoma versus Richard Glossip update, and we are starting part 2. Kyle and I will continue our review of the case against Glossip, who was convicted of the 1997 murder for hire of his boss, Barry Van Treese. In part 1, we talked generally about the case, including Glossip's first trial and direct appeal, his 2004 retrial, direct appeal, and his state and federal post-conviction claims. When we broke off, we were talking about the 2022 propaganda campaign being waged by his advocates in the media and his 2022 state post-conviction claims. We'll pick up where we left off, including talking about the 2 writs currently pending at the U.S. Supreme Court. We'll also talk more about the result of the Oklahoma Attorney General's, quote, independent, unquote, investigation that we learned was directed by Reed Smith and by extension Don Knight. We'll also talk about the disposition of Glossip's 2023 state post-conviction application and the shenanigans involved in that process, Glossip's clemency hearing, and his challenge to that made in the Oklahoma County District Court, along with Glossip's second writ pending before the U.S. Supreme Court. And good afternoon, Kyle, on this wonderful July 2nd.
Yeah, good afternoon. Happy pre-Independence Day.
Happy pre-Independence Day. I do want to make a note, and we are going to record a bonus episode on Wednesday, June 28th. The Texas Court of Criminal Appeals denied the remanded claims in Rodney Reed's case. It dismissed remaining claims raised by him in his 2019-10 post-conviction writ, and it dismissed the 2021-11 writ. Again, Kyle and I will be recording a bonus episode to talk more in depth about the 129-page opinion dismissing the -10 writ and the much more short and to the point opinion dismissing the 11 writ. And we'll be recording that tomorrow, and hopefully I'll be putting it up on either Monday night or Tuesday because we're off for July 4th at my work. So I'll be sitting at home twiddling my thumbs. Much like I do at work all day anyway. Just kidding.
Not shooting off some fireworks.
No, I don't do fireworks, and I'm kind of glad that I don't have a pet right now because it is traumatic for me dealing with the trauma my dog or my cat experience during fireworks. And it's a little scary because I live near an area where sometimes it doesn't sound like fireworks. It sounds more like gunfire.
Right. Well, I don't think they do it as much on the 4th, but, New Year's Eve with the gunfire in the air is always a little bit scary.
Yeah. So, all right. Well, let's get back to Richard Glossip. And we left off, we talked about the AG's response to Glossip's first, or rather, no, his second state post-conviction writ. And I'm just going to go ahead and repeat that since we did that and we were kind of wrapping up. So basically, the response of the AG, and this would have been AG O'Connor, was that Proposition 1, Glossip's Brady versus Maryland claim was without merit, that it was built on a false premise, that the state did not suppress Mr. Snead's desire to renege or to renegotiate his plea agreement, and that the evidence was not material. They argued that Proposition 2, petitioner's allegation that the prosecutor violated the rule of sequestration, is without merit. And again, because the rule of sequestration deals with witnesses being present in the courtroom during testimony and proceedings
Right.
when they have not yet testified.
Yeah. So a witness can't listen to other witnesses' testimony because they could
Correct.
potentially,
The rule of
align or
sequestration
change
does
it.
not prevent one party's attorney from talking about their own witnesses' testimonies with those witnesses. And also, I think that the allegation that the prosecutor violated the rule is also without merit, because the evidence presented by Glossip is that Connie Smotherman wrote a memo to Gina Walker Snead's attorney. And Gina Walker talked to Snead and made notes on that memo and presumably returned them to Smotherman, although that's not really clear. So in the end, if Snead's testimony was influenced, it wasn't influenced directly by Smotherman with Snead.
Right.
It would have been influenced based on his conversation with his own attorney.
Exactly.
So then Proposition 3, that the allegation that the state knowingly presented false testimony was also without merit. And I actually don't remember what the alleged false testimony was. And I should have reviewed that before today. My apologies. Then also petitioner's Brady claim regarding the knife was without merit. And the cumulative error claim was also without merit, because what Don Knight does is he takes multiple claims that have been raised and rejected, and he throws them into these new petitions and says, well, see, these are all errors, even though the court has already said, no, they're not. So, and then on October 16th, this was filed on the 10th. On the 16th, Reed Smith generates a 4th supplemental report. They consulted with an attorney to evaluate the DA memos and materials, and alleged, based on speculative arguments, that the DA violated ethical and legal duties during Glossip's second trial. Well, your paid expert gave you the opinion you wanted to hear. And that's really what it boils down to.
Right.
This isn't somebody that was just given these materials blind and says, what do you think? It was somebody who said, okay, we're looking at this case. The guy is innocent. We know he's innocent. We've proven he's innocent. But we just haven't met the bar in the constitutional violation arena. So we need a constitutional violation to move this across the finish line. And so, of course, their expert gives them the opinion they want to hear. On the 19th of October, in the lethal injection case, the 10th Circuit affirmed the district court's dismissal on summary judgment of the Eighth Amendment challenge to the use of midazolam in lethal injection protocol. The deadline to seek review at the U.S. Supreme Court of that decision was January 9th, 2023. Now, the lethal injection claim was not being handled by Don Knight. It was being handled by other attorneys on behalf of Glossip and multiple other inmates.
Now, why was not? Oh, because that was multiple. I was going to say, why wasn't Knight participating?
It was multiple other inmates, and I don't know exactly why Knight would not have also handled the lethal injection challenge. Perhaps because the attorneys on the lethal injection challenge could not handle the post-conviction claims.
Got it. That makes sense.
And so they were kind of they were trying to split fronts, more or less.
Gotcha.
And then on November 2nd, 2022, Governor Kevin Stitt issued Executive Order 2022-29, in which he granted Glossip a second 60-day stay of execution, effective November 21st, 2022, because his execution date had been delayed or stayed from September 22nd to December, I believe it was 8th. And
Yeah, I
so
think that's right.
Stitt granted this second stay for effective November 21st, staying the December execution date and resetting it for February 16th, 2023. And that would allow the Oklahoma Court of Criminal Appeals to address all the pending legal proceedings. Ironically, the Court of Criminal Appeals didn't need that much time, because on the 10th of November, the Court of Criminal Appeals issued its opinion, basically denying Glossip's first state post-conviction claim filed in 2022. That's PCD 2022-589. They found that their standard of review, of course, is limited by Oklahoma Post-Conviction Procedures Act, which is not designed to provide repeated appeal of issues raised and rejected, which is Don Knight's main agenda or main MO.
Because at the end of the day, you just can't keep re-adjudicating the same thing over and over into perpetuity, which is what they're trying to do.
You know, they dress it up and they say they've got new evidence, but the new evidence isn't any better or stronger than the original evidence that they presented. So, you know, that's why they keep presenting the same claims, and they keep, you know, claiming they've got new evidence or they got better evidence or whatever. But in the end, it doesn't meet the bar that Glossip has to meet. And that's something too that I think the general public is confused about. They think if Glossip files this post-conviction application, the state is supposed to say, okay, just give him a new trial.
Right.
And that's not how it works. And it's not how it works in a state. And the state isn't doing anything wrong by opposing his post-conviction applications. He has the burden of proof.
Yep.
Not the
it's just
state.
practical,
the state doesn't have to keep proving him guilty.
Exactly. The courts, I mean, the courts are clogged enough, but if people
you're fading.
Oh, I'm sorry. Can you hear me okay?
Yes.
It's like, yeah, I mean, that's the thing. It's like, you know, the courts are already clogged, but if people could just continue to re-adjudicate every single trial into perpetuity, justice would be denied for everybody. At some point, you just have to let the system work.
Yeah. So they cited, and once again, I just want to kind of sketch out, you know, their review is limited to errors which would have changed the outcome and claims of factual innocence. That the Glossip must support his factual innocence claims by clear and convincing evidence, which must be more than that which merely tends to discredit or impeach a witness without the probability that the outcome would be different. And that the court weighs the evidence presented by Glossip against the evidence as a whole in a light most favorable to the state to determine whether Glossip has met his burden. They found on Glossip's factual innocence claims that his affidavits do not provide the clear and convincing evidence he would like the court to believe. There's no evidence that Snead ever sought to recant his testimony in any meaningful way. Glossip is raising a theory of defense that has been his claim from the beginning. I think that was the robbery gone wrong claim. The evidence provided by Snead was sufficiently corroborated by compelling evidence, including Glossip's web of deceit and deception while authorities were trying to find Barry Van Treese. Glossip's guilt was proven beyond a reasonable doubt before a jury of his peers, and nothing in his current application causes the court to contradict the jury's verdict. Glossip's application fails to meet his burden of showing clear and convincing evidence that he is factually innocent and this propaganda is denied. And my apologies if you were trying to interject a comment.
No, I mean, I think we say all the time, I mean, you can tell with a lot of these people, if they're innocent, they're not lying and changing their stories, right after the murder. If somebody's genuinely innocent, they don't keep, obfuscating from the police. I mean, that's one of the things that's always, to me, a good sign that somebody's guilty, because why would they just not be completely open and honest from day one if they have nothing to hide?
Yeah, definitely. I totally agree. And, I mean, if Richard Glossip were really innocent, even if he didn't tell the employees the lies he told them about seeing Barry and Barry going for breakfast and buy construction supplies, even if he didn't tell him anything, he wouldn't have opened his mouth. And
Right.
then when the car was found and the police became involved, Glossip would have said, "Hey, come here. Justin Taylor, the maintenance man that's been living here in exchange for fixing stuff that he doesn't really fix.
Yeah,
He
exactly.
came to me at 5 o'clock this morning and said he killed Barry Van Treese and he's in room 102.
Exactly. Yeah, he has no reason to lie. It's like,
He would not have helped cover up the window.
no.
He would not have gone into the room and hung a shower curtain from the inside to keep people from being able to see into the room. He would not have, again, lied to the employees and said, "Oh no, I saw him. He's leaving." He wouldn't have lied to
Exactly.
Donovan Treese. I mean, there are so many lies that he told. And I think that the problem is that a lot of these people, a lot of Glossip's advocates are because Don Knight has disputed some of these statements, they are ignoring all of them.
Right. But I don't think Glossip doesn't even really dispute him, does he?
No, Glossip admitted at his clemency hearing that he lied to Donovan Treese.
Yep.
He admitted to failing a polygraph.
Exactly.
He admitted to these things. So even he doesn't. He didn't at one time. Now he's changing his story. And I think he's the source of a lot of these other stories. The stories about, Snead's girlfriend, which we'll get into, we, kind of got into, Fancy Mercedes or Sherry, whatever her name is. This is all information that would have been known to Glossip at the time. So why didn't he provide it to his attorneys?
Exactly.
Yeah.
Or innocent people behave a certain way and guilty people behave a certain way.
Correct. And that's, and saying I was scared, I'm retarded, I didn't know, I'm stupid, I didn't know, I don't know how to handle things because I don't have good cognitive abilities. That's all just, window dressing bullshit excuses that a jury probably would reject.
Yeah,
especially a jury observing Richard Glossip testifying, who does not seem to be mentally or emotionally challenged.
Right.
Other than being a sociopath. So, as to the remaining issues, the court held that they could have been raised earlier with due diligence or were not raised within 60 days of discovery because Knight was presenting affidavits from 2015, and he was presenting affidavits that he'd had since 2017, 2018, 2019. So he should have presented those things a lot earlier, but Richard Glossip didn't have an execution date, so there was no need to file anything in his mind until there was an execution date that needed to be postponed and held off. They also found there was no miscarriage of justice. The destruction of evidence was known about before Glossip's second trial. Glossip had waived his ineffective assistance of counsel claims because it's based on their conduct for the second trial. They knew about the destruction. And so saying that they were ineffective now is too late. You should have said that in your first state post-conviction act. The due process claims were also known and waived, and Glossip's intellectual disability claims were not supported by clear and convincing evidence. and could have been discovered with due diligence and are therefore waived. They also went on to rule that the errors alleged by Glossip did not result in a miscarriage of justice. Their conclusion, they denied Glossip's application. They denied his evidentiary hearing and discovery requests, and they issued their mandate immediately upon delivery and filing of this decision. And that was done on November 10th, 2022. On the same date, Knight issues a statement, and basically he just continues playing to the court of public opinion, claiming that they have presented all this evidence that proves Glossip's innocence, and the court is just not doing it right, and demonstrating basically that he ignores the findings of the court in their opinion, and he expresses disbelief that they had the audacity to deny Glossip's application or reject his application. And I think there might have been some more court of public opinion statements by McDougal and the other idiot legislators. And, it's the same they're playing to the court of public opinion. They're trying to convince the public that Glossip is an innocent man about to be executed.
Yep. Yeah.
And that's all it is. They know they can't win in court. They know these claims don't work in court because they've tried them already. But they want the public, they want to try and rile the public up. And I think for Don Knight, if he can get the death penalty in Oklahoma I can't
abolished.
think of the word. Abolished. Yeah, that's it. That was the word I was looking for. That it's a win. But I think in order to abolish the death penalty, the voters of Oklahoma, the citizens of Oklahoma have to vote. And that's why they're playing to this court of public opinion.
Yeah, exactly.
Because they think they're going to fool enough people to eventually vote to abolish the death penalty in Oklahoma. Frankly, I think they're wrong. Because from what I see, Glossip's support is not coming out of very many people in Oklahoma, aside from some idiot legislators and from some, hardcore anti-death penalty groups. I don't see a lot of citizen support in Oklahoma.
Yeah, it's always that's exactly what happens, right? It's always the outside influence that's seeking to change and manipulate.
And I have no doubt in my mind that our friends at Victims Innocence Project and Jennifer Harmon and Amy Kingery and several other Oklahoma citizens who have engaged with me and appeared on this podcast would be out there, pounding the pavement and making sure that their court of public opinion claims get zero credibility or have zero credibility with the citizens of Oklahoma. My apologies. I want to say Arkansas for some reason, but citizens of Oklahoma. So then 7 days later, after a week, the second state post-conviction writ, PCD 2022-819, that opinion was issued by the Oklahoma Court of Criminal Appeals. And once again, spoiler alert, they denied Glossip's claims. Their standard of review is the same as their prior opinion. They found that Glossip raised similar claims on direct appeal and in his initial post-conviction application. So this time he's raising the same claims, but he's saying, oh, look, now I have new evidence. And I think this was related to Justin Sneed's testimony. The court found the claims in the post-conviction application were barred by res judicata, which means they've been raised and rejected. You can't argue them again. In Proposition 1, that the state withheld material evidence was procedurally barred and is based on speculation that Sneed lied. Glossip presented no evidence that Sneed had a desire to recant or change his testimony. Sneed's hesitance was known prior to the second trial. Birch gave Sneed case law telling him that the state could not revoke his plea if he refused to testify. Birch's actions were the subject of a court hearing on 11/3/2003, and Birch was removed as Glossip's lead attorney because of those actions. And as an aside, Glossip wanted to fire Birch by that point. Glossip was not happy with Birch. And so when Birch said, I want to withdraw because he had put himself behind the 8 ball by visiting Snead without anybody present to corroborate any claims he may have made about Snead's statements to him, Glossip was more than happy to let him withdraw. And the attorneys that were working, the attorney that was working with Birch had been on the case during Glossip's direct appeal and had continuously represented Glossip up to that point. So Glossip wasn't stuck with new attorneys who knew nothing. He had an attorney who had worked on his direct appeal, which was successful from his first conviction, and he had a new attorney appointed. And he got a continuance because his trial did not begin in 2003 like it was supposed to. So the whole rigmarole with Birch, got him a delay.
Yep.
In the summer of 2004. They also found that the issues could have been presented earlier, and the information presented did not qualify as Brady evidence. They found the information was not new, could have and should have been raised on direct appeal, so it was waived. They found that some of the information was not material and would not have changed the outcome of Glossip's trial. They cited the fact that the jury knew about Snead's deal, that he was the actual killer, and that he was benefiting from testifying. They also found that prosecutor told the court they had talked to Snead about other testimony, so it isn't new evidence that they talked to Snead about the medical examiner's testimony, and it could have been raised earlier and is thereby waived. Because I think there was an on-the-record hearing in which the district attorney told the judge, yes, we talked to him about the medical examiner's testimony. Because I think during the medical examiner's testimony, Gary Ackley had questions and doubts about the medical examiner's testimony vis-a-vis Snead's statements. So, that was, again, something that that Glossip's counsel should have known about before 2022. And then they found Glossip's claims raised in his propositions 2, 3, and 4 had no merit. The allegation that the rule of sequestration was violated was not persuasive, as the statute does not prevent either side from discussing testimony with their witnesses during trial. And now you'll note McDougal has said they violated the rule of sequestration. He posts this opinion, even though the Oklahoma Court of Criminal Appeals has said no, they did not. So what puts McDougal, what makes him the legal expert to refute the finding of the Oklahoma Court of Criminal Appeals? And I would like for him to answer that question.
Right. And somebody needs to hold them
accountable.
Yeah, and somebody needs to hold them accountable just for the, constant spreading of disinformation.
Mm-hmm. Yeah. The argument that the prosecutor elicited false testimony from Snead was based on unsubstantiated conversations, was based on a false premise. And I believe this is because there's no evidence that Smotherman directly spoke with Snead. The evidence presented by Glossip is that Smotherman brought the issue to Walker's attention. And Walker talked to Snead, and Walker may or may not have provided the substance of her conversations with Snead to Smotherman, because it's unclear whether the documents were contained in the prosecution files or whether they were contained in the indigent defense attorney files that were provided to Reed Smith. They also found that Glossip's claims were based on pure speculation. The allegation that the memo could have impeached Snead lacked merit because Snead was sufficiently impeached at trial. The cumulative error claim was baseless when the court fails to sustain any alleged error, and none of Glossop's claims demonstrated a miscarriage of justice or constituted a substantial violation of constitutional statutory right. So again, in conclusion, they denied Glossop's second 2022 application. They denied his evidentiary hearing and discovery claim requests, and they issued their mandate immediately. And that was also on November 17th, 2022. Again, Knight makes a statement that and basically demonstrates he just didn't bother to read any of the opinion. And he plays to the court of public opinion and expresses disbelief that Glossop's claims have yet again been found to be unsupported by clear and convincing evidence. The only other explanation for this is that he just doesn't read the opinions and doesn't understand them, or doesn't understand them if he does. McDougall also wrote an editorial column, sorry guys, that appeared on November 30th, 2022. Again, I have no doubt that he doesn't read the opinions or he doesn't understand what he's reading. And he's so invested in the propaganda campaign that he ignores the mountain of evidence proving Glossop's guilt, and he continues to push the one-sided narrative that Glossop's guilt is in question, in spite of the court opinions that have soundly refuted the propaganda campaign over the years. And then we talked about this on November 30th. Knight had filed a request for funds to pursue certain actions on behalf of Glossop and receive some payment from federal indigent defense coffers. So what he's done since November 30th has been partially compensated by the federal system. So anybody who says he's doing this on his own dime is lying.
So the taxpayers are paying for all this.
And it's interesting, he filed the motion under seal, but the order wasn't filed under seal. And so some of his requests for funding were granted, while others were rejected as unlikely to succeed or simply a new variation on an old theme that had already failed.
Why would he file it under seal?
Well, the argument can be made that he filed it under seal because it was an ex parte request, so that it would become knowledge as to strategy to the Attorney General's office, in theory. But the order wasn't filed under seal. And so the order was accessible, and I downloaded that puppy right away as soon as, because it was filed in Glossop's original federal habeas corpus writ.
Gotcha.
And I'm just, I turn over every rock and look for new stuff always. So then on January 2nd, 2023, an Intercept article comes out. No surprise, it continues the one-sided narrative portraying the state's case as refuted by clear and convincing evidence and ignoring the countless prior legal opinions that refute the author's flawed opinions regarding Glossop's alleged innocence, and in most cases, that refute the actual evidence that they claim supports their opinions. Also on January 2nd, there's an email from Don Knight to Kyle Counts, counsel for the Oklahoma Pardon and Parole Board, posing questions about potential reappointment of Richard Smotherman to the parole board and the procedures and protocols to replace a board member who recuses prior to Glossop's clemency hearing, which was scheduled in January at that time because he had the execution date on February 16th. Then on January 3rd, the Oklahoma Pardon and Parole Board actually postponed all clemency hearings scheduled for January. On January 3rd, Glossop filed, or Knight on behalf of Glossop filed his a writ of certiorari challenging dismissal or denial of his second state post-conviction writ or application PCD-2022-819. That was assigned docket number 22-6500. And the questions presented were whether a court may require a defendant to demonstrate by clear and convincing evidence that no reasonable fact finder would have returned a guilty verdict to obtain relief for a violation of Brady versus Maryland, which ignores the fact that the Court of Criminal Appeals, did not find such a violation. And I think they found that the allegations of a violation were based on a false premise. And whether suppressed impeachment evidence of the state's key witness is per se non-material under Brady because that witness's credibility has been otherwise impeached at trial. And again, the flaw in their reasoning is that the Court of Criminal Appeals did not find Brady violations and went so far as to say that the allegations of Brady violations were based on, I repeat, false premise. And then they argued the reasons for granting the petition were that Brady versus Maryland requires only proof of suppression and materiality. The state suppressed exculpatory evidence, the standard of clear and convincing evidence foreclosing a guilty verdict plainly does not govern Brady materiality, and some impeachment at trial does not render all subsequently disclosed impeachment evidence per se immaterial.
And
what
was the evidence that he claims that was the Brady
violation? This is the evidence, the letter to Gina Walker from Snead that he wants to recant, that he regrets testifying, that he wants a better deal. But again, that's all based on a false premise. It's not a letter to Connie Smotherman saying I lied in my trial testimony in the first trial and I don't want to testify in the second trial. It's a letter to Gina Walker saying, I really shouldn't have relived this and I wish I hadn't done it. And, I shouldn't have testified in the second trial and, second, basically post-trial buyer's remorse.
Exactly.
They also argued that the decision below squarely implicated the questions presented. But again, they're arguing from a false premise because what they're presenting as Brady violations were found not to be Brady violations. So on January 9th, 2023, Gentner Drummond, the newly elected Attorney General of the state of Oklahoma, took office. On the 10th of January, the AG's office did file. Oh, wait, no, my apologies. The lethal injection challenge, an extension of time to file a writ, was filed on the 10th of January. That was 22-A or 22A622. It was granted on the 11th of January, and the deadline to file became March 18th, 2023. That was to appeal the affirmance of the dismissal of the lethal injection challenge by the district court that was affirmed by the 10th Circuit Court of Appeal. That was actually, the extension of time was actually filed a day late. Because if I recall correctly, the deadline was the 9th of January. But even though they were a day late on the extension of time, they got the extension. They were given until March 18th. On the 11th, the Attorney General's office, Gentner Drummond, who we'll talk about a little bit more later, filed an opposition, and they basically argued that the court didn't have jurisdiction over the claims that were procedurally defaulted by adequate and independent state law grounds. They argued reasons for denying the writ. The petitioner's Brady claims were barred in state court by adequate and independent state law grounds. They argued the background of Glossip's claims and that the court lacked jurisdiction over the OCCA's denial of relief pursuant to adequate and independent state law grounds as to propositions 1 and 4. Then on the 17th of January, the parties in state court at the Court of Criminal Appeals filed a motion to reset execution dates pursuant to 22 OS 2021, section 1001.1. It was filed by Drummond requesting additional time. It was not a joint motion, my apologies. It was a file by Drummond requesting additional time between execution dates for Glossip and the phase 2 execution dates set by the court in the 7/1/2022 order. The request for additional times between executions was due to the AG's interviews with DOC staff at the time of Scott Eisenberg's execution on January 12th, 2023, where apparently he claims the staff expressed consternation with the 30 days between execution dates. A brief of amici was filed in the U.S. Supreme Court on the 24th of January. Former state and federal prosecutors supporting Glossip. They found that they argued that his conviction and death sentence were improperly premised upon the unreliable testimony of Justin Sneed, the admitted murderer of the victim, in exchange for his avoidance of a death sentence, which is propaganda. The state failed to disclose material impeachment evidence, including the desire of Sneed to recant his testimony. Again, propaganda, found to be factually insufficient by the Oklahoma Court of Criminal Appeals. And they argued that the death penalty cases demand highest standards of conduct by state actors, but no comment on the conduct of actors on behalf of the convicted person who lie, cheat, and steal in order to advance their cause. A second amicus brief was filed by McDougall in support of Glossip. Again, he argued that American law abhors punishing the innocent, especially when the punishment is death. But the flaw in that argument is that Glossip is not legally or factually innocent. In the eyes of the courts, he's legally and factually guilty. In the eyes of the U.S. Supreme Court, he is legally and factually guilty. He found that he argued that the system must correct miscarriages of justice and wrongful convictions. Again, false premise, because the courts have held that there is no miscarriage of justice in Glossip's case, nor is his conviction a wrongful one. That is McDougall's opinion.
Right. Yeah, and people always mistake the attorney's opinion with actually a court finding a fact.
He argues that denying the convicted a remedy for prosecutorial misconduct only worsens miscarriages of justice. Again, the allegations of prosecutorial misconduct have been rejected.
Well, yeah, and allegations aren't true. I mean, that's the thing, is they'll make allegations because it gets press, and you have people like CNN who just run it uncritically.
Yeah, the allegations of prosecutorial misconduct raised by Knight on behalf of Glossip have been found to be unsupported by sufficient evidence or clear and convincing evidence. So again, it's a false premise. And then finally, he argued that absent the court's intervention, Oklahoma could execute an innocent man. He argued that Justin Sneed's statements inculpating Glossip were manifestly false. New evidence showed detectives fabricated a theory that Glossip was guilty, then coerced Justin Sneed to adopt their story. That's untrue. Sneed immediately abandoned the story the police fed him. That's not true. Independent new evidence supports Sneed's jailhouse admissions. Not true. Murder for hire theory was fictitious. Not true. Kevin McDougall's entire amicus brief is a work of fiction from beginning to end. It's his opinion presented as fact and legal argument.
Do you think a lot of these are filed? I think you mentioned it before, though. Do you think a lot of these are filed so they can get the quote unquote journos, like your CNN people, to read these like they're fact, because they're going to take this non-critically and just say, oh, look at all of this. You get kind of the low information journo and the low
Well,
information CNN watcher that reads these because they think just because they're filed in court, that gives them some kind of credibility.
I think on both sides of the aisle, journalism has fallen from fair, equal,
Yeah, nobody asks tough
unbiased
questions.
reporting of
Yep,
each side to advocacy.
exactly.
Report only the facts that support your position.
Right.
Discredit the facts that don't support your position if you can't ignore them. And misrepresent at will whatever you have to
Yeah,
misrepresent.
anything that contradicts my point of view, I'm going to misrepresent. Exactly.
Yeah. And that is, there are, I mean, we've talked about this I've talked about it with Gary Meese. We've talked about it, I think, with Rob Chadwick. I mean, journalists are no longer journalists, they're advocates.
Exactly. Yep. They're just PR people for whatever
Mhm.
side they choose.
Yeah. And when and I think Roberta Glass did a really great show with someone who was formerly at Intercept. And when Intercept moved from journalism, investigative journalism, to advocacy, he and one of his colleagues experienced workplace bullying and hazing and horrible treatment by their by their colleagues at the Intercept because they did not like and they spoke out about the turn that
Right.
the Intercept had taken. And I unfortunately I don't remember the name of the episode. I would
Well, I don't
invite
think the
Roberta.
founder of the Intercept, I think it's Glenn Greenwald has come out and he's kind of become one of the kind of independent voices speaking up for, what we used to call journalism, where people would
Yeah.
actually try to actually do some research and
And
actually come to, conclusions based on the facts instead of picking facts that fit your conclusions.
yeah. And I would invite Roberta when I post this episode, please in the comments, please post a link to your episode with this discussion of the Intercept's move from journalism and really hard-hitting investigative journalism to advocacy,
Right.
and hiring potheads like Jordan Smith. Um, so, on the 24th of January 2023, Glossip filed his reply brief to the state's opposition, or response brief in opposition to his claim in the U.S. Supreme Court. He repeated that the decision was contrary to Brady versus Maryland, that there was no adequate independent ground applied by the OCCA. They applied a no procedural bar to Proposition 4, which I think was the actual innocence claim. And I think they tried to argue, well, the state didn't raise these bars, so, it can't be applied, which the state doesn't have to raise everything the OCCA can apply. Trust me.
Right.
Whether the basis for a Brady claim has been disclosed is intertwined with the merits of that claim. The arbitrary application of the state's procedural bar rule does not bar review, and that the state court opened its doors to consider Brady claims, and it must grant relief it requires. Then on the 24th, the Court of Criminal Appeals did grant the Attorney General's request to reset Phase 2 execution dates and reset Glossip's execution date for May 18th, 2023. Judge Lumpkin filed a concurring opinion, but he had a little something to say. He basically stated he recognized the executive branch of our state government as a branch vested with the authority and responsibility to execute the laws passed by the legislative branch. The application of the law of our government and the application of the law as interpreted by the judicial branch of our government. So he was required to concur in the results set out in this order. However, the original execution dates on these cases were scheduled pursuant to a schedule requested by the Department of Corrections and Attorney General, allowing 30 days between execution dates. While the 30 days was a longer period than previously considered by this court, it was a reasonable time period and therefore approved by the court. Now the DOC and Attorney General are seeking to expand this time period with no more than a claim of inconvenience, thus moving the goalpost they originally established. The time period between execution dates should have been a part of the due diligence the DOC and the Attorney General considered prior to submitting the original request for execution dates to this court. Changing the time between dates does not assist in addressing the finality of sentence or provide the closure victims seek in the process. So that was what I mean, and he's got a point. The OCCA didn't just, randomly say, okay, 30 days. That was what the Attorney General asked for in the original thing based on consultation with the Department of Corrections. So
Right.
I agree, goalposts were moved.
But they moved them, yep.
On the 26th of January, A.G. Drummond appointed his childhood friend, Rex Duncan, to conduct an, quote, independent investigation,
Of
or
course.
independent, unquote, investigation of Glossip's
Very
case.
independent.
Drummond does not disclose that Duncan has entered into a contract valued at $120,000 with the AG's office, or that his proposed compensation for the Glossip investigation will be in the amount of $30,000. So 1/4 of that $120,000 contract. On January 27th, 2023, the Attorney General gives Glossip's counsels access to a box of files that were segregated by A.G. O'Connor's office with handwritten notes removed from the Oklahoma DA's files by John O'Connor's office. Those were removed based on O'Connor's opinion, I guess you could call it, that these notes were work product, that they contained thoughts, impressions, opinions of the prosecutors that were not discoverable to the defense at the time of trial or at any time during post-conviction litigation. And interestingly, there is no post-conviction duty to disclose material in Oklahoma at this time. So once you're convicted,
You're convicted.
You're convicted, and the state doesn't have to keep sending you new material, whether it's exculpatory or not. They don't have to go through their files and say, oh, well, we didn't provide this at trial, but now we think maybe we should have.
Well, again,
No,
it's just,
there's
I
none
mean,
of
if you
that
think about
bullshit.
it practically, I mean, you can't, I mean, just from a total court, you can't just keep adjudicating these cases into perpetuity. I mean, people have this kind of naive idea that, oh, we're just searching for justice, which, yes, it's fair, we are, but there's got to be some level of, structure and
Right.
process. Otherwise, nobody will get justice if the courts are constantly clogged.
And I think also it's important to point out the district attorney in Oklahoma County had no duty in 2015 or 2021 or 2020 or 2022 to allow Don Knight to look at the DA's files.
All right.
Which again is the impression that Don Knight tried to give in the public court of public opinion. So he provides this box, and this is where the 2023 writ comes from, because they find these handwritten notes and then they speculate and they they, write their false story and they come up with additional claims on behalf of Glossip. But spoiler alert. So on February 6th, the U.S. Supreme Court requested in a letter to the Court of Criminal Appeals the record in Glossip's second 2022 post-conviction application. On the 13th of February, the Court of Criminal Appeals lodged that record with the U.S. Supreme Court. On March 16th, 2023, Don Knight or Reed Smith, probably Reed Smith, goes to Paul Melton, who had provided affidavits previously with the Mercedes fancy girlfriend robbery gone wrong story allegedly told to him by Justin Sneed while they were in the Oklahoma County Jail in 1997. And Reed Smith gets a lengthy supplemental affidavit that serves as the basis for the robbery gone wrong claim cited by Reed Smith in its initial report, and appears to be for the sole purpose of expanding on Melton's prior stories to provide more detail to those stories. Among the factual inaccuracies are Melton's claim that Sneed and the girl, whose name could be Fancy or Mercedes or Sherry, stayed in another motel rented by a roofing crew friend of Sneed's. And they also adds that Sneed strangled Barry Van Treese. Now, as far as in Sneed's flight from the motel, the established facts are that he left the motel, he stayed under a bridge, according to his statement to the Oklahoma City Police Department, and then he went back to the roofing crew and he started staying with one of the bosses of the roofing crew in an apartment in Oklahoma City. There was no staying in a motel. He didn't call a roofing crew friend and get that friend to rent the motel room, as Melton claims. So, again, factual inaccuracies. And then there's no evidence that Barry Van Treese was strangled, although Don Knight will invent that, as we'll see in a few more minutes. On March 17th, 2023, Reed Smith and or Don Knight goes to a psychiatrist by the name of Lawrence Tromka, because on one of the notes in this box 8 is apparently Smotherman was interviewing Sneed or talking to Sneed, and she writes lithium, and she writes Dr. Trumpet, and then she writes a couple of other notes. And initially, what Knight presented was not even legible. But he argued that the trumpet refers to Dr. Tromka. And his ultimate argument is that this note should have been provided to the defense, who then could have, and let me see, more accurately, the prosecution should have looked up who the doctor is, found out he was a psychiatrist, named Dr. Tromka, and then told the defense, hey, Dr. Tromka at the jail is a psychiatrist who prescribed Justin Sneed lithium. I think that's kind of how I interpret Don Knight's argument. So the prosecution was required, based on this misspelled name from Justin Sneed, to investigate it and then provide that information to the defense. That's their argument.
Yeah, that
so they
doesn't make
go
any
to
sense.
Dr. Tromka and they get this affidavit on March 17th, 2023. And he says he was the sole psychiatrist at the Oklahoma County Jail in 1997 through 1998. He says that lithium was a first-line drug used to treat patients diagnosed with, and they redacted Sneed's diagnosis. But I think they've posted in other sources have said bipolar disorder. He examined a medical information sheet indicating Sneed was being transferred to the DOC on 7/8/98, and that he had previously used lithium. That the jail would have had a file with Sneed's medical records, which would have included his notes and diagnosis, as well as medications prescribed. Those records were maintained by the jail, which was run by the Oklahoma County Sheriff's Department. He said he did not keep his own copy of records. So this is important because having Dr. Tromka's name would not have provided the defense with records because he didn't have them. He was the only medical health professional who would have prescribed lithium. Lithium is a psychotropic drug not prescribed by non-psychiatric physicians at the jail. It was not used or indicated for use for dental problems or cold, or would not be confused with Sudafed. Illicit drug use can exacerbate redacted, probably bipolar, and a manic episode can cause an individual to be more paranoid and potentially violent. A manic episode could affect an individual's perception of reality as well as their memory recall. He said Dr. Eve King would have had access to Sneed's medical records maintained by the jail when she conducted Sneed's competency evaluation. And it's important to note her report was addressed to the judge who ordered the evaluation at the request of Sneed's counsel at the time, George Miskovsky III. So the prosecution was not involved in the competency evaluation. They didn't ask for it. They didn't obtain the doctor to do it, and they didn't obtain records on behalf of or have access to those records.
Right.
And I think this is after HIPAA was enacted. So this also defeats one of Glossip's many claims, is even if the prosecution had Justin Sneed's medical records, unless they had an authorization from Justin Sneed to provide those records to Glossip's defense counsel, they could not provide those records.
Yeah, no, absolutely. Yeah, that would definitely be a HIPAA violation.
You have to have a specific authorization.
Yeah.
So if they got an authorization for the doctor to provide them to the prosecution would have to have either within that authorization, and usually our authorizations allow us to provide records to our experts or to the patient upon request.
Right.
They don't allow us to necessarily provide it to co-defendants or co-defense experts. Now, in some cases, we'll alter, like if we're obtaining medical records by authorization, that authorization will include that we can send it to all counsel involved in the case. But we have that specifically in the authorization. Other parties in the case, whatever. It's not included automatically. We have to
you have to get that authorization
to include it. So lethal injection challenge on March 18th, 2023, there was no petition filed, and I have confirmed this with the U.S. Supreme Court Clerk's Office on June 16th, 2023. The lethal injection challenge, the Fifth Circuit's affirmance is final. There is no Supreme Court lethal injection case pending or contemplated, and any attempt now to file would be out of time. And then on the 19th of March 19th, 2023, Don Knight and or Reed Smith, because Reed Smith is now actively helping Don Knight. They were not independent. They're an anti-death penalty advocacy.
Yeah, they're definitely
firm. They were not independent, and Don Knight, McDougal, Humphreys are in bed with Don Knight, possibly literally, not just metaphorically. McDougal for sure. And Reed Smith is in bed with Don Knight. And so they're helping Don Knight by, sending attorneys and giving Don Knight's claims an air of, well, look, we're independent. And this is the conclusion we reached. Well, that's because you only looked at what he told you to look for or look at. They went to Dr. Speth, who had provided an affidavit or a certification in 2015 that was critical of Dr. Choi's examination, her methodology, her evidence, and her opinions regarding Barry Treese's cause of death and the injuries sustained by him. Speth now claims that Mr. Van Treese's cause of death was strangulation based on a red mark on his neck. And this is likely to have an expert to bolster Melton's fantasy-laden affidavit. And the affidavit was notarized or dated 3/19 for his signature, but it was not notarized until the 20th. So there's a little bit of inconsistency, a little bit of red flag going on there. Then they went to Gary Ackley on March 21st, 2023, and they got an affidavit from him. And it's kind of a long affidavit. And he kind of, I'm not going to go into everything he said, but he does kind of defeat their claims or refute their claims about the Sinclair gas station video. He does admit that he spoke to Rex Duncan in early March. He admits to speaking with Reed Smith, Jackson Walker attorneys in 2022 and 2023. He refutes the claims about Bob Macy being involved in Glossip's death sentence in 2004 because Bob Macy wasn't even the district attorney at that time. That was a gentleman by the name of Wes Lane. And he, let's see, he confirms that his notes state that Kayla personally told him she looked at the video while she was at the store the morning of January 7th, 1997 to see when Snead came in, because one of the ultimate claims is that Kayla personally viewed the video and that was never disclosed to the defense. He says his notes do confirm that the Oklahoma City police took the tape, but the videotape has disappeared.
Yep.
It wasn't in the files.
Right. Just conveniently disappeared.
Yeah, I don't think it appears on any evidence inventories. While she thinks they took the tape, she may be mistaken in that belief.
Yeah.
And I think she's now deceased, so there's going no back to her and talking to her. But, the tape ultimately showed the inside of the store. It could have been used to corroborate Kayla Pursley's testimony about the comings and goings at the store the night of Barry Van Treese's murder. It could have corroborated Justin Snead's claim of what time he went into the store that night or early morning. It might have refuted his time or showed that he was off on time.
Right.
But it didn't show the front of room 102 or any view of the hotel.
It didn't show anything that would have been really changed the answer.
He also does not recall knowing or discussing that Snead was on lithium for bipolar disorder. He believes that would have been an important factor for the defense to know and thinks it was Brady impeachment material. He believes the condition was disclosed to the parties to the litigation by filing of a written report in the case by Dr. King in her competency evaluation on 7/17/97. That some of it is his opinion. I'm not going to repeat. He also goes into some of his notes regarding the amount of money spent to refurbish or get the hotel back up and running after Glossip's mismanagement. And his notes made during Dr. Choi's testimony and questions raised by that testimony, but it's not really that germane. It becomes the basis for some of Glossip's claims, but not so much that I really need to go into it here, because again, they're speculative claims, and Ackley's speculation in his affidavit is the basis for some of those claims. On the 27th of March 2023, Reed Smith issued its 5th supplemental report with additional speculative allegations regarding the contents of Box 8 and alleging numerous Brady and Nappy violations and rehashing old issues, including the money in Glossip's possession at the time of his arrest and the amount of money available for Snead and Glossip to steal after Snead murdered Barry Van Treese at Glossip's urging. So on March 27, 2023, Glossip's Knight filed on behalf of Glossip a successive application for post-conviction relief, which was PCD 2023-267. Proposition 1 alleges that the state withheld evidence, including impeachment evidence obtained from Snead prior to the 2024 trial regarding treatment by a psychiatrist and his mental health diagnosis, which was redacted from Glossip's petition, but later identified as bipolar disorder. Now, again, the parties knew, based on that 1997 report from Edith King, that Snead was prescribed lithium in the jail. Brady does not absolve a defense attorney from conducting any investigation. Brady does not require that all information a defense attorney has comes from the prosecution.
Right.
A defense attorney, knowing that Snead was prescribed lithium, could have gone to the jail and said, "Who's your doctor?" Gotten the doctor's name, looked him up, found out that he was a psychiatrist.
Yeah.
If they got an authorization signed by Justin Snead, they could have gotten those records. If they couldn't get an authorization from Justin Snead, they could have filed a request or a subpoena in the court to get those records. And the court
Because
would
there's a
have
lot they
ordered
could
it,
have done that they just didn't bother doing.
and they
if
didn't do
wanted
it,
to. Yep.
apparently.
Which tells you
Or
there's a lot of information and content in the fact of what they don't do.
or they did do it, but then they thought it's probably not a good idea for us to
They
make
didn't like the
Justin
results.
Snead look more vulnerable to
Right.
Glossip because he has a mood disorder and he takes these drugs that make that mood disorder worse, and that Glossip can then tell him things
Yeah, more
and make him
manipulate
even more paranoid and violent than he
All
already
right.
was, or make him paranoid and violent when he wasn't. And pardon, I'm gonna talk a little bit while I'm walking because I'm very thirsty today because it's hot. So, yeah, but
I bet it's
they
hot and
could have,
muggy in New Orleans.
yeah, oh, very buggy. It's like south of hell. So we'll take a little short break. If you need to go get something yourself, by all means, do so. I will say at this juncture that if we still had our wonderful audio editor, this wouldn't be a problem because she could just take all this out. But Emily has moved on to bigger and better things.
What happened to Emily?
Well, she started working a full-time job. She was doing this. She had finished school, and she was doing this pro bono with us, which we very much appreciated. And she began working full-time, which is wonderful. And she needed to concentrate on her full-time work and her full-time responsibilities. And it was becoming more and more challenging for her to
Well, good for Emily.
do
Cheers to
the editing
her.
work
Didn't
for
realize
us.
that.
And that was, I have no hard feelings or no regrets, or I'm glad we worked with her for the time that we did, and I'll miss her, but you get us warts and all from now on, including impromptu Diet Coke breaks. So, um, and I guess if I'd planned it a little better, I could have paused the recording and then come back. But
What's a nice plug for Diet Coke? Maybe we'll get a new Diet Coke ad.
yeah, that would be great. I drove my first Honda for 20 years, 21 years, no, 20 years, and I'm driving my second one on year 15.
Oh, wow. How many Honda
So
miles have you put? Have you gotten 1,000,000 miles yet?
my Civic had just turned 100,000. My CRV is 72,000, I think. I'm a low mileage person.
Yeah, seriously.
So the most miles I put was between New Orleans and Arkansas when I lived in Arkansas. And but since I moved back to New Orleans in 2010, I haven't been putting that many miles. But yeah, I bought it in 2007. And so no, 16 years. I'm in year 16. October will be 16 years. Honda, hook a girl up.
Yeah, seriously, that's amazing.
They are great cars. They last forever. I have not, with my Civic, I had one major problem, which was the computer. And that was after 14, 12 or 14 years. And
Well,
then,
we have a CRV with 160 something thousand miles and the Accord
oh,
with 140 something. So
uh-huh.
yeah, we're definitely we have 300,000 miles of Hondas in our family.
Yeah. And like my CRV, I've never had a major problem. The only major expense I've had is 2 tire changes.
Yeah,
You
that's
know,
not that bad.
that's
Yeah.
that's the only major expense. And thank you to Firestone for working with me to enable me to be able to change my tires. All right, so back to Glossip's successive application. His next claim that Kayla personally viewed the Sinclair video, and they misrepresent Ackley's statement. They imply that she viewed the video before the 2004 trial, when in reality, Ackley's statement says she viewed it on the morning of January 7th, 1997. So that's a lie. The state failed to disclose the statement by Bill Sunday during an interview with Ackley regarding the amount of money spent on the hotel, which Sunday allegedly claimed was $25,000 in the interview, that could have been used to impeach Kenneth Van Treese. But from my reading of the notes for Sunday, it's not clear whether it was $25,000 overall, $25,000 for just the things that had to be done because Glossip had let it get into the state that it had gotten into. It the context of the $25,000 is regarding painters. So, did they hire painters to come in and refurbish the whole every building, every room? Well, yeah, that's going to cost $25,000. But what they spent to fix what Glossip fucked up may have only been 2 to 3,000, or 2 to 4,000, or 3 to 4,000, which was what Kenneth Van Treese testified to. So, with regard to the allegations about Bill Sunday, the context of Sunday's statements and Van Treese's statements, they're taking them out of context and then trying to say, well, see, somebody lied.
Right.
or we could have proven Van Treese was lying, but it doesn't help Glossip whether they spent $4,000 or $25,000. Neither of those amounts of money makes Glossip look like a good manager. So again,
Right. They're just kind of distracting with trying to sort of
yeah.
throw things against the wall to see if anything will stick.
And then the final claim in Proposition 1 is that the state failed to disclose a statement from Everhart, which allegedly included the amount of money Glossip got for sale of his possessions. There's a note that apparently Everhart talked about the things Glossip was selling, and then the number 900 was included in the notes. And so they say, well, see, this proves Glossip sold his things. If he got $900 for a couch and all this money for all these other things, that explains why he had that $1,200 that the court said couldn't be explained. But the reason this isn't a Brady violation and couldn't be a Brady violation under any stretch of the imagination is because Glossip sold those things. Glossip knew how much money he would have gotten for selling his things. And yet he never provided anybody with a figure or an amount.
Yeah, and it goes back to, again, it's the way that guilty people behave. If you're innocent, you turn over as much information as possible to make your case. If you're guilty, you lie and you hide and your stories change.
Yeah. So Proposition 2 are allegations related to the alleged loss, destruction, or withholding by the state of the Sinclair video. Again, it misrepresents Ackley's statement, which is that Kayla Pursley stated that she looked at the video while she was at the store the morning of January 7th to see when Snead came in. That does not mean she looked at the video at any time prior to the first trial or the second trial while it was in the custody of the state. It speculates that the video would have been helpful to the defense in spite of multiple statements that the video showed only the interior of the store, and it speculates that the video was willfully destroyed or that the state still has it in its possession. Although Gary Ackley went back to the DA's office briefly and went through every video in the Glossip case, in the case files for Glossip, and did not find the Sinclair video. Proposition 3, Glossip's due process rights were violated when following the ME's testimony that Treese was stabbed. The prosecutor sought to change Snead's testimony. Now, again, they have already brought this issue in the first or second 2022 writ based on the memo from Smotherman to Walker. However, now they're using it based on Ackley's notes made during the testimony of the medical examiner, and they misrepresent his affidavit, where he states at the time he did not understand her statement and misunderstood the circumstances of the wounds because of their unique nature, i.e., the victim was stabbed with a knife that had its sharp point broken off sometime before the fatal attack, which created atypical stab wounds in Ackley's experience. And they provide additional speculation about the prosecutor's actions and motivations, again, based on notes between Ackley and Smotherman taken during Dr. Choi's testimony, and based on Smotherman's memo to Walker and Walker's notes on that memo. Proposition 4, Glossip is actually innocent, which has been repeatedly rejected as not supported by clear and convincing evidence. Proposition 5, cumulative error, rehashing previously rejected claims, including the intentional destruction of box of 10 items of evidence, which was raised in 2015 and 2022, that prosecutors coached Snead to change his testimony, which was raised in 2022, and is unsupported by any evidence of direct interaction between Smotherman and Snead, because what they produce is from Smotherman to Walker. The Sinclair video, the investigation an investigation not conducted properly by police, which has been raised in 2015 and 2022. An allegation that defense counsel did not investigate, also raised in 2015 and 2022. They allege multiple independent and new witnesses who they have known about since 2015, 2018, 2019, 2020, 2021, and 2022. Polygraph materials lost, destroyed, or fictitious. Again, this was raised 2015 and 2022. They re-raised the use of posters, which was redacted in Glossip's first post-conviction claim. They allege Snead wished to recant, which is untrue, and has been raised in 2015 and 2022. That the jury was given incorrect corroboration instructions, again, previously raised in 2007 and rejected, or raised and rejected in 2007. Evidence released to the family prematurely, impeachment information about Justice Snead's mental health not disclosed. Those issues were raised in 2015 and 2022 and could have been discovered by the defense independently of the prosecution by seeking Justice Snead's medical records from the jail when they learned he was prescribed lithium.
Yeah, he's just continuing to just file stuff over and over. Like, all this stuff seems like it's been adjudicated. I'm still fascinated by how he's able just to continually clog up the courts with all of these useless motions.
They also allege, that Glossip's IQ is at most 78. They make allegations regarding substandard autopsy, which were raised in 2015 and 2022, unreliable and inappropriate opinion testimony from the medical examiner at trial, previously raised. They allege additional Brady material was withheld, that the arrest and intimidation of innocent witnesses by the Oklahoma County District Attorney and AG offices, these were raised in 2015 and 2022, and they argue Snead lacked credibility, which they've been arguing since 2015. Then there was an appendix filed with that, which included a page from her interview notes, from Connie Smotherman's interview notes of Justin Snead. And I just want to stop here and say that what they are saying, what McDougal, what Humphreys are saying in the media about Connie Smotherman, accusing her of committing a crime, accusing her of prosecutorial misconduct, accusing her of lying, cheating, stealing, hiding things. I think that those claims are actionable. And I hope that when the dust settles on all this, that Connie Smotherman will take both Justin Humphrey and Kevin McDougal to task.
Yeah, there needs to be some accountability. Yeah, there needs some accountability for wasting the public's time.
Because they're making these statements in the media. They're not making these statements in court. They're not making these statements in court filings. Don Knight is immunized by the statements that he's making in court filings. But when he goes outside and makes them in the media, I think that they also, once Richard Glossip is finally executed, I think that she also should file against Don Knight for the claims in the media. And I put this out there now, if she happens to listen. If you want, I have most of these things gathered already. I will happily provide them to you. I will scour the internet for every article in which Don Knight has besmirched her character and her name, and Kevin McDougal and Justin Humphreys as well. And I will provide her the evidence to support her claims. And I would also suggest that before anybody deposes her, that there is at the same time a deposition of Knight, Humphrey, and McDougal scheduled, and that those depositions are taken within days of her deposition, so that when they grill her in her deposition, her attorney has equal opportunity to grill them and to gather disputed issues of fact to counter the motion for summary judgment that her deposition will be used to support. And if I knew an Oklahoma attorney who would handle it pro bono for her, I would be happy to recommend such, but I don't. So that I digress, but they're making some really, like I said, they're making irresponsible and untrue
Yeah. Well, they need to be held
allegations
accountable.
against her that they need to be punished.
Yeah. They need to be held accountable for just, libeling people unjustly. Like they just get away with it because it's under the auspices of the innocence fraud movement, but doesn't matter who all they slander or libel.
And a lot of this stuff, like they support their claims about Sinclair video with an October 29th, 2003 email from Smotherman to Birch, which they probably had when they raised the original claims about the Sinclair video. So, it's not new. None of this, aside from the affidavits that Reed Smith got for them, none of this information is new. And, the notes were withheld for a valid reason because they contain sometimes thoughts, impressions, and even strategies of attorneys which are not discoverable. Just as they could not go to Glossip's counsel pretrial and say, give us your notes. That's not how it works.
Yeah, right.
So, and most importantly, the allegations about the notes regarding Cliff Everhart's speculation about what Glossip got for the stuff he sold. Glossip knew exactly how much he got, and apparently, Deanna Wood was able to provide Reed Smith with some receipts for this stuff. So, I mean, Glossip could have provided his attorneys with this information. And then they filed a motion for discovery, which wants a renewed search for the Sinclair video and submission of documentation of the state's search efforts, a deposition of Connie Smotherman to interpret her notes and account for her actions in the preparation for and conduct of Glossip's trial, which I don't understand why Reed Smith did not get this from Connie Smotherman prior to issuing any report or providing any findings to Don Knight. So again, they didn't talk to Connie Smotherman about her memo to Gina Walker. They didn't talk to Connie Smotherman about her understanding of Justin Sneed's use of the word recant or any of these things. So again, this is all just for show. It's all just to make it look like Richard Glossip might be innocent.
Yeah, it's just like making it easy for people to write stories about his innocence and cite all this stuff.
Yeah. As though it's true, even though
exactly. Yeah,
it's ultimately found to lack credibility or not to be true. And then they file a motion for evidentiary hearing that they want to present testimony from Justin Sneed, Connie Smotherman, Gary Ackley, Dr. Choi, Paul Melton, Peter Speth, Larry Tromka, and Chuck Laughlin, who was at the OIDS office and verified Walker's handwriting on the Smotherman memo. They also filed a notice of conflict and request for recusal. And this is one of the most idiotic things that Don Knight has ever done. He wants to recuse Vice Presiding Judge Hudson because he hired Connie Pope, who is now Connie Smotherman, as a prosecutor in 1996 when he was appointed DA for Payne and Logan counties, and that his clerk, Seth Branham, was a former AG who defended Glossip's conviction. Now, Seth Branham, because he worked on prior cases or prior claims made by Glossip as an AG, he's not involved. He's not working as a clerk on Glossip's case for Hudson. But to argue that because Hudson hired Glossip's prosecutor in different counties years before, that he can't be unbiased. or can't be fair to Glossip is the most idiotic claim. And then on March 27th, 2023, the AG and Glossip filed a joint motion seeking a stay of Glossip's execution until October 24th of 2024 to allow the, quote, independent, unquote, investigation by Rex Duncan to be concluded prior to Glossip's execution so that the state can make a fully informed decision about its position. And this is an instance of the AG obviously speaking out of his own mouth. He's just speaking out of both sides of his mouth. He's just looking for a way to try to work with Don Knight and to work with Reed Smith and to delay Glossip's execution from the date in May. And you'll see why I make this statement a little bit later. On the 30th of March, an objection to the petitioner's notice of conflict and request for recusal is filed, I believe, by the AG's office, saying that the allegations against Vice Presiding Judge Hudson lack a factual basis and do not require recusal, that Glossip's experts' opinions are inconsistent, i.e., he believes Hudson should have recused himself because of his former working relationship with Smotherman, but then goes on to state later that Hudson was not required to disclose that relationship in 2015 and 2022. That Hellman fails to explain why Hudson was required to recuse, but not required to disclose the relationship. That petitioner has not met his burden to demonstrate that a reasonable observer will question the impartiality of Judge Hudson, given his prior 3-year professional relationship with Ms. Smotherman. That petitioner's inferences into the exact contours of their relationship should not be given any credence when it comes to making this decision, as they are unsupported and highly tenuous speculation. So, speaking out of both sides, he's wanting to delay the execution, but not agreeing with the recusal request. And also because on April 3rd, 2023, Rex Duncan issued his report. And the reason we know that Duncan's report was not independent is because he credits Knight, Reed Smith, Jackson Walker, and Crow and Dunleavy, all who have worked on behalf of Glossip, as instrumental in navigating a reported 146,000 pages related to the case. And I take that to mean telling me what to look at and what to look for to support Glossip's claims of innocence.
Yeah, 100%. Yeah, he's just basically a stooge.
He also admits to having several in-person meetings with Don Knight and Amy Knight, who assisted in his understanding of their client's defense. He sought expert opinions from Hellman, who was hired by Reed Smith, including the allegations on the notice of conflict and request for recusal filed on March 27, 2023. His findings are that there is sufficient evidence of Glossip's involvement in the murder of Barry Van Treese to support his 1997 prosecution. He found that Glossip incriminated himself as an accessory after the fact during his 1997 interviews and 1998 sworn jury trial testimony. He finds circumstantial evidence supported the state's argument that Glossip was a principal, subject to prosecution for murder in the first degree. However, he states that the case would have been weaker, quote, if full discovery had been provided. And this is, again, his marching orders from Don Knight were, you've got to say there were Brady violations, similar to what was done in Adnan Syed's case. He believes Glossip was deprived of a fair trial in which the state can have confidence in the process and result. Gee, where have I heard that? Oh, wait, hasn't Kevin McDougal made that exact statement?
Sounds very familiar, right? Yeah, it's almost
Was
like
Kevin
they're reading from the
McDougal's
same
hand up
script.
Duncan's butt when he was writing this report? Could be. I don't know. He believes that violations of discovery mandating a new trial under Brady in violation of disclosure requirements under NAPU prevent such confidence. Now, this is the basis. When Justin Sneed testimony, and in Justin Steed's testimony in 2004, and I believe in his testimony in 1998, he said, I didn't see a psychiatrist. I don't know why they prescribed lithium. That I asked for Sudafed for a cold, or maybe because he wanted to cook some meth in jail. Because that's one of the reasons you can't get Sudafed over the counter. You have to go to the pharmacy and say, I need Sudafed.
All right. But you
And
get
that's
it in
why
jail.
when you buy like NyQuil, you can only buy one.
Right.
And they have to get your age. And sometimes for a while in Arkansas, they had to see your driver's license.
Right.
And they took down your name.
Yeah, I think it's still that way, right? In a lot of places.
So, but so they allege that the prosecutor, because of that Dr. Trumpet question mark, that the prosecutor should have gone to the jail, found out Dr. Trumpet was Dr. Tromka, who's a psychiatrist. And so when Justin Sneed, I didn't see a psychiatrist, should have said, wait, Dr. Tromka is the doctor you saw, he's a psychiatrist, or should have told the defense that he saw Dr. Tromka, who's a psychiatrist. I mean, it's kind of a convoluted. They either should have said, well, you're not telling the truth, Justin, because you did see a psychiatrist, or they should have told the defense so the defense could have impeached him. Now, the defense could have said, he was prescribed lithium in jail. Let's find out who prescribed it and why they prescribed it. And they didn't need that from the prosecution. They could have gotten that on their own. So, and maybe they did, but they just didn't want to bring any attention to the fact that Justin Sneed has mental problems. So anyway, so yeah, they claim either that it was a Brady violation for not providing psychiatrist at the jail information to the defense, or NAPU violation because Justin Sneed was making a false statement. He believes Glossip was deprived of a fair clemency hearing in 2014 before the Oklahoma Pardon and Parole Board, and in his subsequent successive applications for post-conviction relief, because Patricia High was a prosecutor and didn't recuse herself. She worked with Connie Smotherman. But the 2014 clemency hearing has zero to do with the 2004 trial.
Yeah, that's 10 years later. It makes no sense it would be related.
I mean, and Glossip testified in his 1998 trial that he failed a polygraph. So again, all this brouhaha about the polygraph and the results and the fact that Don Knight hasn't gotten a report really doesn't have any impact whatsoever on the established fact that Glossip was administered a polygraph. He has admitted that he was administered a polygraph and he failed a polygraph. Now, if he's now telling Reed Smith, they put a colander on my head and it had some wires attached to it, and it was attached to a copy machine. And when I made a statement, the copy machine printed out lie, then, that's Glossip making up a new story. And I think Glossip now is saying, oh, well, I only had a pulse oximeter on my finger, or I only had something on my finger. There weren't any other wires or any other things.
Well, and again, shouldn't have all that come out at his trial? I mean, if all these problems with the polygraph, he should have brought that up.
Why didn't he say that during his testimony? He said he was administered a polygraph.
Yeah, seriously, he should have said all this way, way early.
Correct. So he's a liar. He's a liar, 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 liar. I cannot say this enough. I cannot stress this. Liar, liar, liar.
Yep. Well, and that's the consistency with all these innocence fraud cases, is their stories never make sense. And they never bring it up during their trial. It's always 25 years later.
Yeah. How can you tell Richard Glossip is lying? His lips are moving.
Lips are moving, exactly.
So then he gives a history of the case, and he alleges that the interrogation tactics to get Justin Sneed to identify Glossip as a principal rather than a mere accessory were wrong. Well, that's an issue that Sneed can raise, but Glossip doesn't have any standing to raise it. He says that Sneed eventually claimed the murder was Glossip's idea, and he went along with it because he saw no other way out. Glossip maintains that he was not administered a polygraph, but fitted only with a simple fingertip device like an oximeter. Well, he's lying to you. If he told you that, he's lying. If Reed Smith tells you that that's what Glossip told them, he lied to them. So he has specific concerns whether a polygraph was conducted. He says Firm Smith informed Fornerat that the polygraph results were in the record and available to him to examine. That no ADA or defense attorney stated on the record he saw or she saw the polygraph results. It's still disputed whether a polygraph was conducted. Bullshit. Glossip says one was conducted. Period. End of story. In my view, evidence in murder cases is to be maintained in perpetuity. Apparently, the polygraph was not maintained. It was not placed in the court record. Again, it wasn't used against Glossip at his trial. It's not relevant to his trial. Whether or not it was administered, whether or not it was accurately interpreted, whether or not Glossip could have found an expert to say he was telling the truth, all of that is irrelevant to his trial because the polygraph was not mentioned at his trial. The destroyed evidence, again, this isn't new evidence. It was destroyed. It was known about before the second trial. It could have been raised at the second trial and was not raised by Glossip's attorneys. It's old news. Evidence returned to the Van Treese family. Again, old news because prior to the 2024 trial, the Glossip's attorneys found out about this and they didn't make a stink. Missing Sinclair video. Again, old news, not relevant, not used against Glossip at trial, not used in Glossip's trial, not referred to in Glossip's trial. And we have testimony that it did not show anything but the interior of the store. And so only could have corroborated a very, very small bit of testimony from Kayla Pursley about when Sneed came in and could have potentially proved that Sneed, the meth head, got the time wrong when he said he went in the store. But that wouldn't have changed the outcome of Glossip's trial. Failure of Glossip's 2004 trial attorneys. Sneed's plea agreement was used as leverage to compel Sneed's reluctant testimony in the 2004 retrial to avoid the death penalty. Based on the 2001 decision in Dyer, Sneed was entitled to a new plea agreement or any alternative relief from testifying at Glossip's retrial. Yes, and Sneed was told about that Dyer opinion. But really all it meant was he could have refused to testify and they could not have reneged or vacated the plea agreement. It doesn't mean that he could have gotten a new one. It only means that he could have refused to testify without without the original agreement being vacated. He found that neither Glossip's defense attorneys nor Sneed's attorney challenged the post-Dyer use of the 1998 plea agreement. Again, that doesn't have any, Glossip doesn't have any standing to use Dyer. And Sneed, Gina Walker probably, chose not to try and use Dyer because in the end, that's not what Sneed really wanted. Because he knew about Dyer and he'd been told about Dyer by Birch. Sneed was compelled to appear as a witness for the state by trial subpoena. Well, yeah, your point. There is none. It has no relevance, again, to the fairness of Glossip's trial because it's not a violation of any right of Glossip's. In fact, it gives Glossip the chance to impeach Sneed's credibility. The court, the 80s, and both defense attorneys, all state employees, were silent in 2004, failing to make a record with respect to the Sneed's plea agreement. Again, this has nothing to do with Glossip. Rex Duncan potentially was not a very good prosecutor, because if he thinks these are good reasons to undo Glossip's conviction, he's stupid.
Yeah, he didn't seem to have a lot of confidence in his original case. It doesn't make any sense.
He's inventing reasons based on his marching orders from Reed Smith and Don Knight.
Right, just to
because he's inventing the same reasons that they have raised.
Yeah.
And they have alleged. He brings up the communication between Smothering and Walker following the ME testimony, which really doesn't show any change or attempt to change Sneed's testimony. Again, he's repeating the allegations and speculation given by Knight regarding attempts to change Sneed's testimony, which aren't borne out by the actual fact that Smotherman issued the memo to Walker. Walker talked to Sneed and wrote notes on the memo that may or may not have been provided to Smotherman. And he says the memo was from Smotherman to Walker. The notes in the margin of the memo have been verified as those of Walker. So that doesn't prove any firsthand contact with Sneed by Smotherman. Nor does it prove any effort by Walker to get Sneed to change testimony. So, and then violations of Brady allege a handwritten pad made during a pretrial meeting with Bill Sunday. Told Ackley that $25,000 was spent on repairs and maintenance, but actually the $25,000 was mentioned in context of hiring a painting contractor in those notes. So, he says Glossip did not have access to $25,000 for motel maintenance, but doesn't take into account the breadth of disrepair by the time Glossip murdered Barry Van Treese, or had Barry Van Treese murdered. He's alleging that that Glossip should have been provided with these notes so they could have impeached Kenneth Van Treese, but it's difficult to use notes. He could have, if Sunday testified, he could have used it. When Sunday said, I don't remember, they could have used it to impeach him on that. But they couldn't have necessarily used Sunday notes to impeach Van Treese, because you can't use a statement made by Sunday to impeach testimony given by Van Treese. Sunday's statement is based on his knowledge. Van Treese's testimony is based on his knowledge. He may not know what Sunday paid to a painting contractor. So it's always funny when they say, well, these could have been used to impeach another witness.
Well, right. And you can ask, they wouldn't want that same standard used in trials in general, right? Because you can't do that. It would be unjust. If you were to apply that to other cases, they'd be outraged.
Yeah. And if you try to use a statement made by Deanna to impeach Glossip's testimony, that she's not repeating a statement Glossip made, she's repeating a statement somebody else made to her, you can't do that. So, and then failure to correct Sneed's false testimony about his medical condition and treatment. Now, one of the reasons that I believe Sneed could have said, I didn't see a psychiatrist, is because he may not have perceived his treatment in the jail by Tromka to be psychiatric. Sneed may have thought psychiatric treatment involves going in an office and laying on a couch and talking about your problems and talking about your mother. And
exactly. He might have just thought it was just counseling or just a friend talking to him.
Yeah. And it may not have been counseling. It may have been going in. How are your moods? How is your anger? How is this? How does the medication work for you? Okay, good. You stay on it. You're done. There would be no psychiatric type working through the problems. It's just a Band-Aid on a problem. And again, I'm speculating because I don't have Justin Sneed's mind, but why don't they go? They've interviewed Justin Sneed. Why don't they go and say, well, you said you didn't see a psychiatrist. Why would you say that? Dr. Tromka is a psychiatrist. Only psychiatrists prescribe lithium. So why would you say that? And find out from Sneed why he would say, I didn't see a psychiatrist in his testimony. And it's not material whether he did or didn't see a psychiatrist, whether he perceived Tromka as a psychiatrist or not. And really, his diagnosis is not material because it is a mood disorder. It is not, except potentially in a manic state, it is not something that would have affected his testimony or his ability to perceive reality and fantasy at trial or during original events. Again, only if he's in a manic state would there be some influence on his perceptions.
Right. Yeah, it feels like another distraction just to say, oh, he might have some mental issue. And it doesn't have anything to do with the veracity of his testimony.
So, and again, it all ties into the defense knowing who Tromka was and his diagnosis, that they could have used that to impeach Sneed's credibility, memory, and truthfulness. But again, they did not need this note with the name Dr. Trumpet. The note does not say psychiatrist. The note does not say bipolar disorder. There's no evidence that the prosecutor ever had any knowledge or documents dealing with Tromka or a diagnosis of Sneed. And so they could not have provided something to the defense that they didn't have. They have a name of a doctor, and they're not responsible for investigating that and determining it's a psychiatrist and then saying, oh, by the way, defense, he's a psychiatrist. His name is Dr. Tromka. And again, I said it before, I'll say it again. The defense was always able to investigate the prescription of lithium. And all of that would have cascaded into this knowledge about seeing a psychiatrist and a diagnosis. So again, they're claiming a violation for something that the defense could have learned independently of the prosecution or any information held by the prosecution. And that, my friends, is why none of this is Brady. And then there's NAPU allegation of not correcting the false testimony. But, again, that's not on the defense. I mean, that's not on the prosecution to correct.
All right. Exactly.
And they may not have, there's nothing in the notes that says Trumpet was a psychiatrist. So maybe they didn't know that he was seen by a psychiatrist. And a lot of this is based on Duncan's beliefs that have been fed to him by Reed Smith, Don Knight, and probably Kevin McDougal and Justin Humphreys, who are probably promising Duncan backing, and they have contributed to Duncan's campaigns in the past and will likely do so in the future. And then he argues High's failure to disclose her professional relationship with Smotherman during the 2014 clemency hearing was some kind of violation, but that has nothing to do with Glossop's 2004 trial. So how it has any relevance, Duncan does not explain. And then he cites to the fact that in 2015, Knight sought Sneed's medical records and didn't get them, but he ignores that since 2015, Don Knight has done nothing to unseal the medical records in federal court or to pursue Sneed's medical records in state court proceedings. And again, it's just based on his belief and his repeating the propaganda that death penalty cases must receive the greatest scrutiny of discovery compliance, erring on the side of transparency and disclosure. In my view, such was not the case herein, and too much, everything is at stake. Again, I think I've heard this from an idiot legislator, or from Don Knight, or from
one of the
Christina
the same
Vitale,
talking
or
points.
from one of the other advocates that has apparently stuck a hand up Rex Duncan's ass and is now moving his mouth and operating his brain for him. So anyway, long story short, because I'm getting tired of this bullshit. Duncan recommends that Glossop's conviction should be vacated due to its decades-long failure to disclose what I believe is Brady material, correct what I believe was false testimony of its star witness, and what I believe was a violation of the court-ordered rule of the sequestration of witnesses. The case demonstrates why withholding entire documents is dangerous. Legal pads with contemporaneously handwritten witness interview notes are documents. Trying any case a third time is unfortunate and rare, but I believe is appropriate in this case. Oh my God, Rex Duncan, you are just, you're so fucking transparent.
Tell us how you really feel.
That you're just repeating what is being told. You're just repeating what has been told to you to say by Don Knight and Reed Smith. It was not independent. It was not an actual investigation designed to get the truth. It was designed to get grounds for the Attorney General to join Don Knight, perhaps because of political pressure placed upon Gentner Drummond by Kevin McDougal and Justin Humphrey. So I'm thinking all the way around, under the surface, there are ethical violations galore between the legislative and executive branch, who are also impugning the integrity of the judicial branch, and their claims have no merit whatsoever. So on April 6th, 3 days after he gets this report, Gentner Drummond files a response in support of petitioner's successive application for post-conviction relief. He alleges that Sneed made material misrepresentations in his trial testimony regarding his psychiatric treatment and the reason for his lithium prescription, not in reality, not material. He doesn't believe Glossip is innocent. He alleges there were multiple and cumulative errors, such as violation of the rule of sequestration, which the Court of Criminal Appeals has already said no in the 2022 application, and destruction of evidence that, when taken together with Sneed's misstatements, warrant a remand to district court. He denies most of Glossop's allegations of error or legal conclusions. He believes that Sneed's alleged failure to testify accurately regarding his lithium prescription and treatment warrant post-conviction relief. He alleges Glossip was not made aware of Sneed's treatment by Dr. Tromka at the second trial and was not aware of this until he received the prosecutor's note. But again, the defense could have investigated who at the jail prescribed lithium, why it was prescribed, and what kind of doctor prescribed it. They did not need that note, which does not say psychiatrist and does not say Tromka and does not say bipolar disorder. So again, they are using something insignificant and speculating and making it sound like it's something it's not. He
Right.
argued
Just
the
trying to
state.
make something making something sound really scary to distract.
Well, no, and this is where impugning Connie Smotherman's integrity comes into play as well, because they're making it sound like she hid something that she should have disclosed, when the reality is what she didn't disclose is insignificant. And it's information the defense could have determined all by itself by investigating why Sneed was prescribed lithium in 1997 by jail physicians. So he also argued the state is not comfortable asserting that the outcome of the trial would have been the same if Sneed had testified accurately. Well, again, we don't have anything that proves that Sneed, when he said, I didn't see a psychiatrist, is a lie. Because we don't know if he knew Tromka was a psychiatrist. And he could have been impeached about that if the defense had done their own homework.
Right.
So he falsely portrays Sneed as the state's key witness at the second trial, which isn't true, because the key witness for the state at the trial, at both trials, was Richard fucking Glossip. They had Richard's statements to Billy Hooper, Cliff Everhart, Kayla Pursley, Jackie Williams, Tim Brown, BMO, Cook. They had his interrogation on the 8th. They had his interrogation on the 9th. I mean, everything, every lie that he told, every false statement that he made was before the jury. Sneed's testimony was icing on the cake, or the cherry on the top of the sundae. Sneed's testimony solely provided connection between Richard Glossip and Sneed's murder of Van Treese. But Richard Glossip's statements and lies provided consciousness of guilt, which gave the jury the evidence that they needed to convict him as a principal in Barry Van Treese's murder, because only a principal in a murder would hide the body for 17 hours, would prevent discovery of the body for 17 hours, would lie about seeing the victim after he knows the victim's dead, would lie about being told the victim was killed and when, would lie about the victim's vehicle. I mean, because he knew the vehicle was over in the parking lot.
Right. Yeah, innocent people don't behave that way.
So, the state believes that qualified defense attorney likely could have attacked Sneed's ability to properly recall key facts at the second trial. Again, the defense should have done their own homework then. And it's too late to raise ineffective assistance of counsel.
Yeah, exactly.
The state has reached the difficult conclusion that the conviction of Glossip was obtained with the benefit of material misstatements to the jury by its key witness. If they falsely state that the competency evaluation was administered by a psychiatrist when Dr. King was a psychologist. And again, this is where nobody has their fucking story straight, because Dawn Knight at the clemency hearing said she was a psychologist, not a psychiatrist. So states the defense did not have the information regarding Dr. Tromka, but again, they knew Sneed was prescribed lithium, and was a fact that he testified to at the 1998 trial. Even if they didn't have King's competency evaluation, they had his 1998 trial testimony. And so they could have discovered Dr. Tromka's identity and status and diagnosis all by themselves. They didn't need anything from the prosecutors. And if they knew that information and they chose to let it slide when Sneed testified, then there is no violation for Richard Glossip. Because again, they decided not to bring light to the fact that Justin Sneed has a mental disorder, has mental problems, and is vulnerable to somebody manipulative like Glossip. The state believes it must concede error under NAPU. The state feels compelled, consistent with NAPU, to correct these material misstatements and request the case be remanded to the district court. They also cite to Glossip's multiple errors, such as the violation of rule of sequestration and the destruction of various pieces of evidence. But both of those were already rejected by the OCCA in its 2022 application. So why the state is using that as grounds now, I don't know. Maybe they're trying to supplement the cumulative allegations made by Glossip. So the state has carefully considered the voluminous record in this case. I call bullshit on that one. The constitutional principles at stake and the interest of justice. If they considered that record, they would have known that the defense was aware of the destruction of evidence in 2003 and didn't raise it, and that the OCCA rejected Glossip's claims in 2015 and again in 2022. And they finally state the state has changed its position based on a careful review of the new information, which isn't really new, that has come to light, including its own independent counsel's review, to bring about a just result. And what they're proposing is not a just result, because the majority of the fact witnesses against Glossip are dead. So the state cannot bring them to testify to the statements that Glossip made to them in 1997 while he was hiding Barry Van Treese's body. So it would not be a fair result. Now, there's a lot of talk in the court of public opinion, and the belief in the court of public opinion was that because now the attorney general says, ooh, there's error, that the Oklahoma Court of Criminal Appeals was obligated to vacate Glossip's conviction and return the case to the district court for a new trial. And another reason that this is not fair is because now the district attorney in Oklahoma County likely would not retry Glossip. She likely would let him go.
Yeah, exactly.
There also is the fact that, according to her opinion, what he did was never principal to first-degree murder, so she would never charge him as a principal to first-degree murder. He would only be potentially at risk of accessory after the fact.
Right. Yeah, in a lot of these cases, right? I mean, you get a new DA 20 years later, and the DA isn't, the DA is not really held accountable. They don't have any interest in retrying these cases, especially with the mounting public opinion.
So basically, and I think that McDougal and Humphrey and Knight saw the fuckery that went on with Adnan Syed, and they thought, ooh, here's our chance. So they put political pressure on Drummond. Drummond found somebody who would be led by the nose by Reed Smith and McDougal and Humphrey and Knight, and who would find what they wanted to be found. And then Drummond would support vacating their original conviction, or vacating this conviction. And then there would be no retrial. Glossip would go free, and they would claim innocent man exonerated. Even though at most he would be granted relief on a technicality that has nothing to do with his guilt or innocence. And they saw the fuckery that went on with Adnan Syed, so they decided fuckery can go on in Oklahoma County now as well. And luckily, the Oklahoma Court of Criminal Appeals was no Melissa Finn, and they did not play that game, because on April 20th, 2023, the Oklahoma Court of Criminal Appeals unanimously denied Glossip's 5th application for post-conviction relief, number PCD 2023-267. They denied the joint application for stay of execution. and they denied the request for a hearing and discovery, and they ordered their mandate issued upon delivery and filing of this decision. Now, I want to go into the findings, and I'm going to try to slow down a little bit. I know I tend to speak quickly and read fast, but I'm going to try and do this slowly because this, ladies and gentlemen, was one of the best decisions I have ever read in my 35 to 40 plus years of reading criminal appellate opinions. The court said this case has been thoroughly investigated and reviewed in numerous appeals. Glossip has been given an unprecedented access to the prosecution files, including work product, yet he has not provided this court with sufficient information that would convince this court to overturn the jury's determination that he is guilty of first-degree murder and should be sentenced to death based on the murder for remuneration or promise of remuneration aggravating circumstance. His new application provides no additional information which would cause this court to vacate his conviction or sentence. Glossip's request for leave to amend is not well taken because this wasn't it. He filed this application and he said he's still reviewing the shit, so he's got to amend. He wants to amend to add additional claims related to the destruction of evidence, I believe. Court review is limited by the Oklahoma Post-Conviction Procedure Act, Title 22 OS Supplement 2022, Section 1089 D8, which provides for the filing of subsequent applications for post-conviction relief. Again, the Post-Conviction Procedure Act is not designed or intended to provide applicants with repeated appeals of issues that have been previously raised on appeal or could have been raised but were not. The court's review of subsequent post-conviction applications is limited to errors which would have changed the outcome and claims of factual innocence. This court's rules also place limits on the raising of issues in subsequent applications. These time limits and the Post-Conviction Procedure Act preserve the legal principle of finality of judgment. This court's rules and our case law, however, do not bar the raising of a claim of factual innocence at any stage. Innocence claims are the Post-Conviction Procedure Act's foundation. Claims of factual innocence must be supported by clear and convincing evidence. Factual innocence claims are the method to sidestep procedural bars in order to present the risk of a manifest miscarriage of justice. And the evidence of factual innocence must be more than that which merely tends to discredit or impeach a witness. We weigh any evidence presented against the evidence as a whole in a light most favorable to the state to determine if Glossip has met his burden. In order to prevail on factual innocence claim, Glossip urges this court to re-examine the previous claim of actual innocence along with what he calls new evidence. The items he relies upon in this new post-conviction application do not meet the threshold showing that Glossip is factually innocent. Melton's current affidavit is not substantially different from the one provided in 2016. Melton's recollection now is more detailed. Because the affidavit basically contains the same information available in previous application, the matter is barred under the Post-Conviction Procedure Act. We are not convinced that the affidavit shows that Glossip is factually innocent. The affidavit merely provides impeachment evidence without showing that the outcome would be different. Glossip's second affidavit is from medical doctor Peter Speth, who attempts to discredit the medical examiner's report regarding Van Treese's cause of death. Dr. Speth provided a report to Glossip's attorneys in 2015. Glossip submitted medical affidavits attacking the medical examiner in his 2015 post-conviction application. This court found in 2015 that this is a claim that could have been raised much earlier on direct appeal or in a timely original application through the exercise of reasonable diligence, that the facts underlying the claim were not sufficient when viewed in light of the evidence as a whole to show that no reasonable fact finder would have found Glossip guilty or would have rendered the penalty of death, and that Glossip has not suffered a miscarriage of justice based on this claim. There is nothing extraordinarily new in SPEC's 2023 affidavit. Therefore, further review of this matter is barred under Oklahoma law. Moreover, the information is insufficient to cause this court to believe that Glossip is factually innocent. The affidavits contain claims that were known or could have been developed earlier with reasonable diligence. These affidavits do not provide the clear and convincing evidence that Glossip is factually innocent. Glossip's claims that the state withheld material exculpatory evidence, but even if this claim overcomes the procedural bar, the facts do not rise to the level of a Brady violation. To establish a Brady violation, a defendant must show that the prosecution failed to disclose evidence that was favorable to him or exculpatory, and that the evidence was material. Material evidence must create a reasonable probability that the result of the proceeding would have been different had the evidence been disclosed. The mere possibility that an item of undisclosed information might have helped the defense or affected the outcome does not establish materiality. Glossip claims that the state failed to disclose evidence of Justin Sneed's mental health treatment and that Sneed lied about his mental health treatment to the jury. Though the state in its response now concedes that this alleged false testimony combined with other unspecified cumulative errors warrant post-conviction relief, the concession alone cannot overcome the limitations on successive post-conviction review. And that is according to 22 OS Supplement 2022, Section 1089 D8. The state's concession is not based in law or fact. This issue is one that could have been presented previously because the factual basis for the claim was ascertainable through the exercise of reasonable diligence, and the facts are not sufficient to establish by clear and convincing evidence that but for the alleged error, no reasonable fact finder would have found the applicant guilty of the underlying offense or would have rendered the penalty of death. Sneed in 1997 underwent a competency evaluation by Dr. Edith King, which noted Sneed's lithium prescription. This report was available to previous counsel, so counsel knew or should have known about Sneed's mental health issues. Furthermore, Sneed testified at trial that he was given lithium while at the county jail prior to trial, but he didn't know why. Counsel did not question Sneed further on his mental health condition, which counsel knew about or should have known about. It is likely counsel did not want to inquire about Sneed's mental health due to the danger of showing that he was mentally vulnerable to Glossip's manipulation and control. Moreover, and controlling here, is the fact that this issue could have been and should have been raised with reasonable diligence much earlier than this fifth application for post-conviction relief. The evidence, moreover, does not create a NAPU error. Defense counsel was aware or should have been aware that Sneed was taking lithium at the time of trial. This fact was not knowingly concealed by the prosecution. Sneed's previous evaluation and his trial testimony revealed that he was under the care of a doctor who prescribed lithium. His testimony was not clearly false. Sneed was more than likely in denial of his mental health disorders, but counsel did not inquire further. Finally, this evidence is not material under the law. The known mental health treatment evidence does not create a reasonable probability that the result of the proceeding would have been different had Sneed's testimony regarding his use of lithium been further developed at trial. Glossip next claims that the state failed to disclose that witness Kaylee Pursley viewed a videotape recording of the Sinclair gas station taken the night of the murder. Kayla Pursley testified at trial that there were cameras at the station for the inside, but not the outside. She testified that Snead came into the station around 2 to 2:30 a.m. No further inquiry was made about the cameras by either side during the trial. Arguably, the videotape was not disclosed to Glossip prior to trial, nor was it utilized at trial, and has not been discovered as of this date. Pursley, prior to trial, possibly told prosecutors that she viewed the tape to see when Snead came in the store. Again, this issue could have been presented much earlier. Counsel should have known that there were cameras at the station in reading the trial transcript and could have inquired about possible videotapes. Issues about missing tapes could have been raised much sooner, and they were raised in 2015. Glossip has waived this issue for review. Obviously, the tape could have corroborated both Snead's testimony and Pursley's testimony. Glossip offers mere speculation that the tape might have been exculpatory and cannot show that the tape was material under the law. Next, Glossip claims that the state failed to disclose details from witness statements that conflicted with other evidence. One such statement relates to the amount of money spent on repairs after the murder. Kenneth Van Treese testified that they spent $2,000 to $3,000 for repairs, and the motel was in disrepair because of Glossip's negligence and rather than lack of money. Another person, Bill Sunday, possibly told prosecutor Gary Ackley that they spent $25,000 for repairs. The amount spent presents a conflict, but it does not help Glossip. The theory was that Glossip was negligent in his job. He expected to be fired, and he chose to have Van Treese killed instead of being fired. There was money spent for repairs, but Glossip didn't do the repairs. The contradiction hurts rather than helps Glossip. Next, Glossip cites to notes by prosecutor Connie Pope Smotherman discovered in Box 8. Glossip speculates that the notes relate to items sold by him. Glossip's theory at trial was that the money he had was from selling some of his items rather than money stolen from Van Treese in conjunction with the murder. Glossip speculates that these notes regarding amounts of money were amounts learned from Cliff Everhart. Everhart testified that Glossip sold items for around $250 to $300. The notes do not clearly have an amount of money. There is no factual basis for this part of the claim. Moreover, Glossip has not shown that this information is material. Next, Glossip raises a claim regarding the now missing Sinclair Station video mentioned above. Glossip previously raised issues regarding this missing tape in case number PCD 2022-589. There is no dispute that a tape was retrieved from the Sinclair gas station or that Snead visited the station. Snead testified that he was there before the murder. This claim is waived as a claim regarding the missing tape could have been raised much earlier. Glossip claims that he has now learned that witness Pursley possibly watched the video to confirm that she saw Snead in the station at around 2:15 a.m. Glossip says the tape could have been helpful to the defense. This is far from being material. The mere possibility that an item of undisclosed information might have helped the defense or affected the outcome does not establish materiality. In Proposition 3, Glossip claims that the prosecution tried to change Snead's testimony to include the fact that in addition to beating Van Treese with a baseball bat, he also attempted to stab Van Treese. Glossip admits that this claim was raised in a previous application, but he has new information to support this claim. Despite Glossip's argument, this claim is substantially the same as the previous claim presented in Proposition 3 in case number PCD-2022-819. This claim is barred under our rules. Lastly, in Proposition 5, Glossip raises a cumulative error claim combining the propositions in this application with issues raised in previous applications. Only claims argued in this application may be combined under this claim. His cumulative error claim must be denied. A cumulative error claim is baseless when this court fails to sustain any of the alleged errors raised. Petitioner's reliance on Valdez versus State to overcome the procedural bars to claims waived or barred is likewise not persuasive. None of his claims convince this court that these alleged errors have resulted in a miscarriage of justice. This court has thoroughly examined Glossop's case from the initial direct appeal to this date. We have examined the trial transcripts, briefs, and every allegation Glossop has made since his conviction. Glossop has exhausted every avenue, and we have found no legal or factual ground which would require relief in this case. Glossop's application for post-conviction relief is denied. Neither an evidentiary hearing nor discovery is warranted in this case. Further, because Glossop has not made the requisite showing of likely success and irreparable harm, he is not entitled to a stay of execution. We have denied the application for relief, therefore his reasons for a stay are without merit. The legislature has set forth parameters for this court in setting execution dates and in issuing stays of execution. The joint request for a stay does not meet the standards of the statute, as this court has found no credible claims to prevent the carrying out of Glossop's sentence on the scheduled date. And then there was a special concurrence by Judge Lumpkin, who stated for over 20 years the facts, evidence, and law relating to this case have been reviewed in detail by judges and their staffs through every stage of appeal allowed under our Constitution. At no level of review has the court determined error in the trial proceeding of this petitioner, nor has there been a showing of actual innocence. As this court's opinion notes, finality of judgments is a foundational principle of our system of justice. Petitioner has received every benefit offered by our system of justice, and now his conviction and sentence are final. For these reasons and the analysis set forth in the opinion, I concur in the judgment of the court and in the denial of this application. And the mandate issued denying PCD-2023-289 and also denying the stay of execution. So now I believe
That was a
Kevin
thorough opinion.
McDougal made some inflammatory statements in the press and the media, and I don't recall whether this was directly after the April 20th opinion or whether it was later, but he basically claims if Richard Glossip is actually executed, he will seek to impeach every member of the Court of Criminal Appeals. Bullshit.
Yeah, it's like way to attack the legitimacy of the court just because you disagree with it.
Yeah. And I think really, the time has come for the citizens of Oklahoma to take a good long look at both McDougal and Humphrey, their improper actions, their unethical actions with relation to Richard Glossip's case, and to ensure that when they next come up for re-election, they are not back in the legislature, because they're only going to do harm to the citizens of Oklahoma. And they do not care about safety of the citizens of Oklahoma. So on April 24th, the AG sent a letter to the Pardon and Parole Board, basically supporting Glossop's bid for clemency based on the speculative allegations and arguments in Duncan's report and that had been rejected in the Court of Criminal Appeals opinion denying Glossop's 2023 application. Also on the 24th, Don Knight filed a petition for declaratory judgment in the Oklahoma County District Court, which was assigned CV-2023-1001, which essentially challenges the authority of the Pardon and Parole Board to conduct Glossop's clemency hearing in the absence of a full board of 5 members. And I'm not going to go through the claims or the causes of action or the relief requested in the original application, because it was amended to include additional, or to, I guess, revise his claims after the clemency hearing. The clemency hearing was held on April 26th. with the usual propaganda presentation by Don Knight, with a presentation made by Reed Smith, which Drummond, because he was supporting Glossip's clemency request, ceded his time to Glossip's advocates. This was one of the most atrocious examples of shirking of a duty by an Oklahoma attorney general that I've ever seen in all of my life, because he gave his time to advocates for Richard Glossip, who then got up there and told the same lies that they've been telling since 2015. And repeating the same propaganda that the Court of Criminal Appeals has soundly rejected since 2015. And the worst part is that Donna Van Treese and members of the Van Treese family were forced to speak out against clemency, unsupported by the Attorney General, who's supposed to be their advocate, not the advocate for the convicted killer. And Derek Van Treese made a beautiful statement, and I'm only going to quote a part of it, but anybody who didn't observe it directly, there are printed versions of it available, and I would suggest that you read it in full. While I agree that the state must take all reasonable action to ensure the adherence to the law, the information in the packet sent by the Attorney General to the board is simply unconscionable to me. Every item listed is rebutted by the appeals court answer. This unprecedented response shows an unbelievable level of disrespect to every person involved with this case and to our family. Enough is enough. The time is now. I urge you, I beg you to allow justice to finally be served through the word of law and the will of the people by denying clemency. Richard Smotherman is married to Connie Smotherman, who was the original trial prosecutor. So he recused. So there were only 4 members on the board. This was also kind of a bleh board, because nobody sought to question Knight or the Van Treese family or Glossip, who made a brief statement, or Reed Smith or the Attorney General. Everybody just kind of took in the testimony and the statements and the lies and the propaganda from Glossip's side and let it go unchallenged. But when it came time to vote, the vote was 2-2. Glossip needed 3 votes. He didn't get 3 votes. Clemency was denied. On the 26th, at the same time, proving that Don Knight does know how to do legal work and does know how to do multiple things at one time, an unopposed application seeking the stay of execution was filed in the U.S. Supreme Court to allow for consideration of Glossip's pending writ and to allow for filing of a writ seeking review of the OCCA's 4/20/2023 denial of the 2023 post-conviction application. So this shows that while Glossip was pursuing the lethal injection challenge, Don Knight could have been pursuing all of these alleged post-conviction claims that he was developing while he was writing those propaganda letters to David Prater at the Oklahoma County District Attorney's Office. But he chose not to do that because Glossip didn't have an execution date pending. And that's the only explanation there is. Because he's getting these affidavits and he's developing all this evidence and he's fleshing out this robbery gone wrong because he's getting the claims that the girlfriend was named Fancy, or maybe it was Mercedes, or maybe it was Sherry. But he's getting all this information, but he's not filing a post-conviction application.
Right.
Okay. But here he's got an application seeking a stay of execution ready to go when clemency is denied on April 26th.
Yeah.
On the 1st of May, the DA, the AG, filed a response to the unopposed application, arguing that Glossip was likely to succeed on the merits of the forthcoming petition, that the balance of equity strongly favor a stay of execution, On May 4th, Glossip filed his petition for writ of certiorari, and that was assigned docket number 22-7466. Now, 22-6500 is still pending. And in spite of having the record since February and scheduling it for conference, the Supreme Court chose to sit on their hands and just let it go because their term is over now. It's not going to be just, it's not going to be reviewed now until they come back in October. But they chose not to do it. And I wonder if that's the liberals on the court who just kept not being ready to conference it. Because they know it's not going to be granted. So they're trying to give Glossip do him a solid by making sure, well, at least we're going to run out this term and not do anything with it. So his second one's filed. And this is, I'm not going to go into the questions presented or the reasons to grant, because it's something that I'm sure we'll talk about once ultimately. I think that the Supreme Court ultimately is going to deny cert because the grounds given for denial and the fact that the claims do not meet the evidentiary standard are going to be fatal to Glossip's writs in both claims, because what he represents the evidence as is not what the evidence actually is. And so we'll talk about that in more depth later, but for right now, he's challenging the dismissal of the NAPU claims and the Brady claims related to the disclosures or the information discovered in box 8 from the work product. He also amended his petition in the challenge to the clemency hearing, and that was amended to reflect that the hearing was held with only 4 members. Knight objected, but he went forward with the hearing. So that may prove to be a problem for him. He raises several claims, and basically he wants the district court to stay his execution pending a final ruling on the motion for preliminary and on a motion to be filed for preliminary injunction and final resolution of the constitutional issues raised by the court of last resort. A lot of it is just blah, 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 not worth discussing. It's bullshit. It's just another way to try and basically ask a court that may not even have any jurisdiction, because this is a criminal case. The only court that may have jurisdiction would be the Court of Criminal Appeals.
Right. It's just more distractions for the press, right?
Yeah. And more propaganda, although they're actually being pretty quiet about this. I think probably because they know it's bullshit. On the 5th of May, this U.S. Supreme Court did stay Glossip's execution to give them time to review or to dispose of the petitions in 22-6500 and 22-7466. There was a mean statement, but basically because it gave the impression that might be done expeditiously before May 18th, because it said, should both petitions for writ of certiorari be denied, this stay shall terminate automatically. And so that made me think, well, maybe they are going to conference it finally and they're going to dispose of it. And then May 18th came and went and they didn't. So the stay of execution from the Supreme Court was filed in the district court action. It was scheduled for conference in 22-6500 was scheduled for conference, but was rescheduled on May 9th, and no new conference date was posted. On the 23rd of May, the Pardon and Parole Board filed a response or an answer to Glossip's petition. And basically they urged that it be denied, and that the amended petition be dismissed with prejudice because he was failing to comply with service requirements and failing to name indispensable parties, and asking a court without jurisdiction to act, and multiple things. So again, this is something I have a feeling we'll touch on again, so we'll go into more detail later.
Right. When do you think
Um,
this is going to be resolved?
I think it's ultimately going to be dismissed by the district court. Now again, I'm going to go through some of the other things going on, and we'll get to that in a few minutes. The AG on May 31st filed a request seeking an extension of time to July 5th to complete preparation of his response to Glossip's 22-7 whatever 74 whatever 66 or whatever it is writ, to address any new arguments made in amicus briefs, because they knew that amici were going to be filing briefs on June 5th. And so the AG, because Glossip can't necessarily respond to amici's points, he can only respond to the opposition or response filed by the state. Drummond is going to respond to the amici briefs. And that was granted. So he's got until July 5th. That was granted on June 1st. Now, there were two briefs filed in support of Glossip. One was by the Innocence Project, which shows, that they'll take up the case of any overwhelmingly guilty person and claim he's innocent. And they argue that the government's conduct of the Swords Estate is acknowledged committing, in this case, is an overwhelming factor in wrongful convictions. And by discounting the state's confession of error, the Court of Criminal Appeals undermined a key remedy for wrongful convictions. Now, this is something interesting, and this is something that potentially the voters of Oklahoma might be able to take advantage of in a vote of no confidence or a recall for Gentner Drummond, because by, quote, confessing error, unquote, Drummond is potentially exposing the state of Oklahoma to a wrongful conviction judgment by Glossip if Glossip's conviction ends up being vacated. And that's not a good thing. So, the state, Oklahoma taxpayers may end up on the hook if it's not going to be successful because it's bullshit, but I'm just saying. So anyway, and then a group of law school professors, I think, filed a brief in support of Glossip's, arguing that prosecutors have an unqualified constitutional duty to correct false testimony that is relevant. Erosion of NAPU obligations would undermine the legal profession's ethical rules, and the OCCA decision is at odds with NAPU and widens confusion in the lower courts. And then finally, the best of all, an amicus brief was filed on behalf of victim family members Derek Van Treese, Donna Van Treese, and Alana Mileto, who is Barry Van Treese's sister, and the District Attorneys Association in Oklahoma joined them in an opposition to Glossip's petition. They argued that the questions presented: does this court have jurisdiction to review a state court's denial of a fifth collateral attack when that denial is based on the state's successive petition statute? The petition clearly does not meet the statutory criteria for consideration, and there is no claim that the state ground is inadequate or not independent of federal law. Does the state attorney general's confession of error reopen an otherwise barred claim when the state court has already considered and rejected the claim and the confession, finding that the attorney general cannot waive the state procedural rule. The evidence in question was known to the defense before trial, and the evidence is not material. And basically, they argued that the Supreme Court lacks jurisdiction because the OCCA's decision rests on adequate and independent state grounds, that Glossip is clearly guilty of aggravated murder. There's no significant federal question of review. There is vast evidence establishing Glossip's guilt beyond any reasonable doubt. No new evidence exists, and prosecutors never concealed anything. And the Attorney General's dissatisfaction with the ruling below is not itself evidence and does not warrant granting certiorari. They also argued that compounding the decades-long delay in obtaining justice will inflict immeasurable harm on the Van Treese family. The Van Treese family is being victimized by excessive delay, and research confirms that what the experience of victims makes plain. Undue delays in the administration of justice harm victims of violent crimes. And this was authored by Paul Cassell, who is a criminal justice rock star, superstar. I would love to interview him someday. He has stood as the opposition to people like Badu and Radele, who put forth a false wrongful conviction study. And he pointed out every flaw in their study and every flaw in the facts that they use to underlie or support their opinions about the ultimate guilt or innocence of the cases that they profile in that study. Excellent. He has helped point out some of the flaws in application of Miranda and expansion of Miranda over the years. So he has been a staunch victims advocate. He's also served as amici for victims' rights and victims of crime in before the U.S. Supreme Court. He was a 10th Circuit Court of Appeal judge for a time, but I think that required him to step away from some of his victims' rights work, and he elected to retire and go back to victims' rights, more hands-on victims' rights work. So he's a great attorney, and there's another another attorney, and his name is escaping me right now. He's a great victims advocate, and he has produced some excellent work regarding the Kevin Cooper case. And I'm so sorry, his name is escaping me right now, but he's also great. And I would love to interview him too, especially about the Kevin Cooper case. So that's my fangirling regarding the Van Treese family brief.
Yeah, the
Anyway.
Kevin Cooper case is another interesting one.
Yeah. And I plan to someday look at it. It's one, though, I think we're going to need like a month hiatus to give me adequate time to go through everything, because I need to create for that notes similar to what I do for all these other cases.
Right.
And Kevin Cooper's been going on since 1985.
Yep.
So it's going to be a major, major task. I probably have to work every night during the week in addition to every weekend. Anyway, so but I will put it on the docket. I will put it on the docket soon. Okay, so on the 12th of June, the Oklahoma Department of Corrections filed a motion to dismiss with a brief in support in the Pardon and Parole Board challenge case in Oklahoma County District Court. And basically, it argued the district court does not have jurisdiction to stay in execution because 22 OS section 1004 states No judge, court, or officer other than the governor can reprieve or suspend the execution of the judgment of death, except the warden of the said state prison, to whom he is delivered for execution, in cases provided in the next 7 sections, unless an appeal is taken. And some of the reference conditions that can be used by a warden to stay an execution is mental incompetence or pregnancy, neither of which is applicable to Glossip, or in the context of an appeal, and then only the Court of Criminal Appeals may stay an execution date or issue any order which effectively stays an execution date per 22 OS section 1001.1c. Now, you would wonder, well, Glossop's execution date on 5/18 didn't go forward, so why would they be worried? Because the Supreme Court stay will dissolve when his petitions are denied. And even though Gentner Drummond appears to be in collusion with Don Knight and Reed Smith and not inclined to request a new execution date, and where the Oklahoma County District Attorney is not probably inclined to request an execution date either, the Court of Criminal Appeals is able to set a new execution date once the Supreme Court stay dissolves under state law. So that is why the Department of Corrections is ensuring that the district court doesn't try to issue an invalid stay of execution on behalf of Glossip. Proposition 2, they argue that plaintiff's request for a stay is moot, given that plaintiff filed notice of a notice on 5/5 advising that his execution had been stayed by the U.S. Supreme Court. And the conclusion was that the court lacks jurisdiction to stay plaintiff's execution, and the request for relief is otherwise moot, and so the action must be dismissed in its entirety. And that is where everything stands. I checked this morning. Nothing new has happened. Everything is awaiting determination of the writs at the U.S. Supreme Court, which, as we discussed a little bit earlier, will not occur until they come back in October of 2023. Kyle, the marathon is over.
I know there's a lot of stuff out there for sure.
It was a lot, and I promise I will go into more detail about the writs at the U.S. Supreme Court once we have a final determination on them. And I apologize for skipping over, but I get the sense that I'm bombarding people with too much information now. And so let's have a little respite.
Yeah, it's very detailed. It's a lot of good info, but yeah, it's a lot to digest.
Yeah. Yeah. And I think the biggest takeaway is that the prosecution never concealed anything, because the information they claim was concealed could have been obtained and may have been obtained. They haven't gone to Glossip's original trial attorneys and said, hey, did you seek out this information and obtain it? So, but yeah, they pardon my sipping. But yeah, they could have obtained this information. They either chose not to do so, or they did get it and they chose not to highlight it because it made Snead look more vulnerable to Glossip than he already did.
Right.
And that is a valid it's a valid strategy. So but do you have any thoughts, any questions, any comments?
No, I mean, I think it's a lot of detail. Yeah, it'll just be interesting to how all this resolve. I mean, I think I've said it a couple of times now. I'm amazed at how I'm just generally amazed at Glossop's ability to sort of keep rehashing the same thing over and over again and just continues to kind of clog up the courts. But hopefully this will be resolved soon. He feels like he's gotten definitely more than his fair share of, quote unquote justice.
Yeah. He certainly has it. He's enjoyed 25 years of due process. And
yeah, for sure.
As we recall, and I know, thank you, Jennifer Harmon, she posted the juror's letter that I read to Governor Fallon that was sent on September 14th, 2015. But I fixed the notes, and I wanted to go ahead and read the closing paragraph in full because I think I'd cut it off a little bit. The real tragedy in all this media hype is the real victim, Barry Van Treese, and his family has been forgotten. I cannot fathom the pain and suffering this family has endured in the past 8 years. The murder of a loved one, 2 trials, appeals, Supreme Court decisions, etc. This case has touched and impacted countless lives, including mine and all the jurors. Richard Glossip is not the victim. I am sure Barry Van Treese would have loved to have had a stay of execution, been given 2 or 3 more chances, and an extra 18 years added onto his life. He was not afforded that luxury nor given that opportunity. Richard Glossip has had his day in court twice. We did our duty. Now it is time for the state of Oklahoma to do hers. It's time justice be served. And that was written by juror number 1 from Glossop's second trial to Governor Mary Fallon ahead of Glossop's 2015 execution date and in response to Don Knight's propaganda campaign regarding Glossop's innocence or alleged innocence. So, and that I think is a good point to close.
Yeah, absolutely. It's hard to say it better than that. That was perfect.
At the end of the day, the only victim in this case is Barry Van Treese, and by extension, Barry Van Treese's loved ones, his wife Donna, his son Derek, his other sons and daughters, whom he had 7 children. He had 2 who were very young, one of whom begged him not to go to Oklahoma City that day.
Yeah.
Which is heartbreaking.
Yeah.
His sister Alana, his brothers Ken, I know Ken's name. Unfortunately, I don't know that I know all the siblings' names. I believe his parents were, or at least his father was still alive at this time. So, I mean, he had a huge family. He had grandchildren. He had grandchildren he's never met because he was taken. So they are the only victims. Richard Glossip is not a victim. Kevin McDougal is not a victim. Justin Humphreys is not a victim. Don Knight is not a victim. Amy Knight is not a victim. Reed Smith is not a victim. They are advocates for Richard Glossip. They are lying. They are spreading propaganda. They are telling you things, say something they don't say. Documents say what they don't say. And it needs to stop. It needs to end. I'm all for due process, but not telling the same lies to a court time and time again solely to prevent justice from being administered to your client. There comes a time when it has to stop. And hopefully, this next execution date for Richard Glossip will be the one that goes forward, because there will not be more collusion with his advocates by representatives of the state of Oklahoma. Or Gentner Drummond will finally come to his fucking senses and take his head out of his ass and go ahead. And now that he's been soundly rejected by the U.S. Supreme Court, to say, okay, time to stop fucking around and let's do it.
Yeah, very well said.
So, all right. Well, let's go ahead and call it an afternoon. This is an extra long show, by the way. We're
Yeah,
at 3
no,
hours now.
you put a lot of work into it. So I know the listeners will really appreciate that. Very, very thorough.
And I hope time flew for everybody because it sure did for me.
Yeah, no, absolutely. Well, everybody take care and have a happy 4th of July and a happy Independence Day.
Yes, definitely. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I plan to record a bonus episode addressing the Texas Court of Criminal Appeals' recent denial and dismissal of Rodney Reed's -10 and -11 post-conviction claims issued on June 28, 2023. Then we hope you'll join us in 2 weeks for episode 9, Oklahoma versus State Anthony Sanchez. In July 2004, Sanchez was linked to the December 20th, 1996 kidnapping, rape, and murder of Oklahoma University graduate Julie Buskin via a cold case DNA hit. We'll talk about the evidence against Sanchez, his trial, direct appeal, and state and federal post-conviction claims, including his recent actual innocence claim, pointing the finger at his deceased father, Glenn Sanchez, who allegedly admitted that he was the real killer in statements he made between 2020 and his 2022 suicide. Until then, have a great 2 weeks. Have a happy and safe 4th of July, and just stay safe.